Good morning, everybody. Woo! Wow. So last night I didn't get to stream because my internet was out. Called Verizon. They said, yeah, your internet's out. We'll send someone over there and then we'll upgrade you next week. And they started talking to me all these crazy deals. And it was impossible to get them on the phone. You don't care about any of this information. You want me to get to Karen Reed. But the bottom line is I ended up getting an upgrade. So now I'm coming to you faster. Instead of at 15 megabytes per second, at 300 megabytes per second. I hope I don't confuse you because I'm coming at you so fast. Just all right, let's get in here. Let's get in here. It does feel faster, right? It does. It feels way faster. It feels way faster. I don't know if there was any testimony today, but we're going to see what happened in court. I see they're on extended break. I think I'm like 3 minutes behind if there is any. I don't know if this might be a very short stream. Might be a very, very short stream. This is what I saw going on here. I started here. I mean, if I back up here, this is just everyone milling in the courtroom. All right, let's see what we got here. Let's see if she comes in here. Let's see what we got.
Good morning.
For the record, before the court is Comal versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial.
Thank you. So good morning. I heard the counsel wanted to see me about something.
Yes, please.
All right, why don't you come on over to sidebar?
Oh, there goes that. Okay. That's sidebar. There's sidebar. And Karen Reed goes up there. I don't mind it as much when the jury's not there. That I don't have a problem. St. John, member 15 months. Good morning, leader, watching from Louisiana. Beautiful. Baton Rouge. Well, thank you for stopping on in, brother. I hope I can make it worth your while. I don't know. I'm just going forward 5 seconds at a time, making sure I don't miss nothing. They said they plan witnesses for this afternoon. They're on a field trip to 34. Are you telling me I'm going to... This is going to be very short. I have a feeling it's going to be very short. This is going to be very, very short. Let's see what we got. It's going to be viewed by like 200 people. Still muted. OnlyFans. Yeah. Nothing. Not even anyone there in the courtroom. I think they all know.
Okay, thank you.
You absolutely did not. Come
I know I'm late. I had internet issues. And there's nothing. I don't know. Layback law today. What Eric told us was on that.
All right, you're okay.
Oh, this would be the state's idea if they're doing it at this point in the trial.
Hear ye, hear ye, hear ye. All persons having anything to do before
Likely.
the Honorable Beverly Cannoni, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
God needs to save.
The court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk.
God needs
Good
to
morning
save the
again,
Commonwealth
Counsel.
of
Good morning again,
Massachusetts.
Ms. Reed. Good morning, jurors. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things and we were successful. So we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yeah.
Everyone nodded.
You didn't.
Affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Have you done any interviews yet?
Said yes or no.
Have you done any interviews?
Did any of you happen to see, hear, or read anything about this case since we left yesterday? No. Thank you. Everyone said no.
All right.
Folks, as you know, this morning we are going on a view. And a view is
That's better than
simply,
going on
we're
the
going
view.
to a place that you've heard about and that you will continue to hear about during the course of the trial. The purpose of the view is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings. So the view that we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict. So we're going to, you've heard 34 Fairview Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yannetti and Attorney Little. The lawyers will have the opportunity, Mr. Yannetti and Mr. Brennan, have the opportunity to point out various things that they may want you
That'd be hilarious.
to direct your
They
attention
drop snow
to.
everywhere.
Otherwise, there's no conversation between the lawyers and the jurors. So it's simply in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yannetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look at. While you're in the view, you're not to take any notes. You're not to take any pictures. You're not to conduct any independent investigation at all during the view or any time during the trial. You're not to return to this scene or ask anybody to go back there for you. Today's your chance. You'll see photographs during the course of the trial, I bet. But today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look. It's really no more complicated than that. So your responsibility is to see the place, observe it carefully, and to remember what you see. Now, during the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. We'll be accompanied by court officers who will direct you. And the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view opening?
May I?
Please.
Thank you, Your Honor. Good morning, ladies and gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. We have some exhibits that are already in evidence. You haven't had a long time to look at them, study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different.
Why is her car going to be there?
From that area where the flagpole is. You'll see on the street before the grass.
Because now her car has a broken tail light. It sort of will fix the broken tail light in their minds with this property.
So the weather will be very different. The temperature will be
You
different.
think?
Conditions will be different.
Oh, we haven't seen tons of video about the snow that night, and we heard a million times about the blizzard, the great blizzard of 2022.
When you look at the Lexus, a couple things I'd ask you to look at. There is some
Yeah, I can join over there. I probably will join over there in a moment.
Right rear tail light. When you look at that tail light, it will be different than the photograph that is in evidence. It has
I just texted him and asked.
Very differently, and you'll later get testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height from the right rear tail light. And I'd also ask you to
Okay.
make note of
I guess seeing the car,
there is
it probably helps the defense if the car is there more. I think about it. Now I'm thinking about it. You could see
Right.
like,
Thank you, Mr. Brennan. Ms. Gianetti?
how did that hit? How did it hit his arm?
Good morning. As I told you at the start of the trial, my name is David Gianetti. I have an office in Boston and in Durham. And on behalf of my co-counsel, we will be accompanying you on the view that you will take today. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom. You've already received in evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are
Seriously.
the best computer that you could bring to the view. When we get to 34 Fairview,
I guess,
we will be pointing out.
man, if Whoopi shows up at the view,
we'd like you to observe.
if they see Joy Beha there,
Second floor window.
they go running and screaming if I was on the jury.
The three front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn. The distance between the front doors to the house and that front lawn. The distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus. Just stand next to it. To size it up, to take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of Ms. Reed, we have every confidence that you will do a proper investigation. Thank you.
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this
I
case.
texted him.
The observations that you
And
make
Frank.
while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look. Okay? Those are the instructions. We will see you in a few minutes. All right? Thank you. Oh, sorry. Madam Clerk has to swear in the court officers.
You could all raise your right hand, please. Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues. that you'll keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
All right, thank
All
you.
rise, please. Jurors, follow me.
Goodbye.
Goodbye. Goodbye. Goodbye, viewers. Goodbye. All right, so we're on extended vacate till they come back. Nothing happening here. Look at this. Live streaming, nothing's happening. Okay. All right. So I asked Nick if he wants me to join, and Andrew. I haven't heard back from them yet. Some folks are saying they want me to join. I will hang out here for a few minutes in case they haven't seen it yet. Let's see what's going on. What are they talking about? Are they even talking about the trial? Are you talking about the trial, Nikki? Nikki.
Particular country. Maybe you're afraid of the government there or of gangs there or whatever. And there's some ambiguity about whether the order of withholding was for El Salvador,
Oh, it's my
his
trend that
nation of
they're
citizenship,
talking about
or
Kareem Garcia.
Guatemala.
Yeah.
It doesn't matter. If it's for Guatemala, and the reason this is an issue is because we ultimately sent him back to El Salvador, deported him to his nation of citizenship, as you normally do.
Bye, guy.
So there's two, and people are saying, well, he had an order of withholding to El Salvador. You
We
can't
need a-
send him back there because of this order of withholding to El
I need
Salvador.
a link to jump
Well,
over.
Either the order of withholding was actually for Guatemala, in which case sending him to El Salvador was fine, or the order of withholding was for El Salvador, and sending him there was still fine because Armando Abrega Garcia's status changed before we deported him. He changed, he graduated from being a typical illegal migrant to being a terrorist. In February of this year, Secretary of State Marco Rubio said, I am designating MS-13 to be a foreign terrorist organization. That means every member of MS-13 is a terrorist. Abrego Garcia had been adjudicated by 2 courts to be an MS-13 member back in 2019. And now in February 2025, he's graduated to being a terrorist. Guess who is not eligible for an order of withholding? Terrorist. They don't get it. So the fact that he had one in his pocket for 6 years,
That's a great
he
point.
should have used it during the 6 years. The moment he became a terrorist, that order of withholding became null and void as a function of law. And
Wow.
we could send him.
That's a great point. I haven't
anywhere.
heard anyone make
So
it.
where'd we send them? Where we normally deport people back to their nation of citizenship, El Salvador.
And so immigration laws are really, it's simultaneously really complicated and really simple. The interesting thing is these district court judges muddying up immigration and the court's role in it. The court's role is not to step in front of the president's decisions on immigration and deportation, because these are matters of foreign relations directly. I mean, if Trump's bringing the president of El Salvador into the White House to explain why this is a foreign relations issue, you're already in the purview of the president, and he is, according to the Supreme Court's own doctrine, he's the sole organ of foreign relations, and decisions that are made by the executive in regards to foreign relations matters are plenary, and the court's ability to step in and have any discussion on them at all is limited. The only thing the court is able to do is to recognize the potential that a deportation back to a home country could have some, I guess, some violation of someone's rights because their home country is so terrible. But there's an amnesty process. But that amnesty process is run by the executive.
I'm gonna mute myself.
And the Supreme Court's job in this field is really to make sure that constitutional rights that are due to a person are being respected. And that's a weird balance, but the judiciary has overstepped so far into immigration, which is, again, matters of foreign relations are the president is the sole organ there. Congress has plenary authority to set immigration naturalization standards. So between those two entities, the judicial branch really shouldn't be making any of these decisions. I mean, I cannot figure what the Supreme Court has to say about, again, about MS-13, unless there's some finding that naming them a terrorist organization is somehow incorrect. But Congress has the authority to do this, and Marco Rubio is going through the process, or the executive has the authority to do this, and Rubio is going through the process of doing that under his delegated power. So where's the court coming in here to say, well, no, these guys can't go here?
Well, they have, so the general jurisdiction, federal district courts have a role here. It's just a very modest role because Congress took immigration away from the district courts as a subject matter jurisdiction. Congress created separate courts, immigration courts. General district trial courts don't have immigration authority. What that means is all the findings, the factual conclusions are made by the immigration courts. Are you a terrorist? Are you deportable? Do you get asylum? All these things, those are findings made by the Article 2 immigration courts. What you can do is you can go to the federal court and say, well, that finding was never made. There's a mistake here in my deportation. I'm not a member of TDA, so I don't fall within the scope of the Alien Enemies Act. I'm actually a U.S. citizen. I'm not deportable in this way. So you can have the federal district court just look at the record and say, well, was a finding of deportation made? But if it was, that's it. It's over. The federal district court doesn't get to redo the finding. They just get to verify that there's not some miscarriage of justice happening here. Just like they can do habeas. That's basically what habeas is. Someone's grabbed by ICE. They're detained. They're going to be deported. They have a right, even under the Alien Enemies Act, they have a right to demand to be presented in the court, maybe not physically presented, but their case to be presented to a court and challenge the conditions of the Alien Enemies Act. Are you 14 years of age or older? Are you a Venezuelan citizen? Are you a member of TDA? Are you not a citizen of the U.S.? But if those things are true, the federal district court has nothing more to do with you. You are deported subject to the Alien Enemies Act. The habeas is only to save people from an actual error. I am an American citizen. I'm not a member of TDA. Well, then, of course, you shouldn't be deported under the Alien Enemies Act. But you'll see how few of these TDA guys demand their habeas rights because it's pointless. They are 14 or older. They are TDA. They're not American citizens. They are Venezuelan citizens. So demanding habeas, which, by the way, can be an extremely efficient process, just a few minutes of paperwork filing, it doesn't help.
I got the link. I'm heading on over there. I'm going to join them. I'm going to join up with them. So, how should I do this? How should I do this? So I don't like this thing. All right, going on in. But I'm doing this now. I'm going to open up just the screen which I have this on. So I have to figure out if I have a problem with that. I might have a problem with double echoing. I think I have to mute myself here. To mute myself here and then just play for you. That's the way I'm going to do it. I think that's what I haven't done this in a while.
To the president, and now has interfered directly in foreign relations. Speaking of non-foreign relations, hey man, how's it going? If you're trying to figure out how to stream on your own side, you're doing everything wrong, Joe. Everything. Oh, you yeah, if you I don't think you can merge into your existing stream from here. Maybe. I don't know. I want one more viewer from you, please. Joe, Joe, I every time I travel, I send you a picture. I know your people are watching me already. You could just directly. It's never. They're always there. It's always like a group of them just off to the side of the frame. It's like, what are they doing there? How'd they get here first? They always know where I'm going. Oh my God.
Yeah. Kilmar, Armando, Abrego, Garcia. Maryland man. He's so multifaceted. Maryland man, wife abuser, human trafficker, terrorist. Is there anything that Abrego Garcia cannot do?
Wait, so did I see a picture of this guy? And he like, I swear I saw a picture of him. He looks like a guy in like a construction vest. He looks,
Yeah.
he doesn't like, he's not 800 pounds of jack muscle with face tattoos all over the place, right? He looks kind of more normal. What I love. You want listen, it was an escape room and they couldn't.
Well, we don't know it was human trafficking. I mean, he was just driving between Texas and Maryland with 8 people in his car of apparent Mexican descent, and he didn't know any of their names. He's driving with 8 people he doesn't know. What are these people's names?
None of you have been on a road trip with your Mexican best friend's family, I guess. No, my point in that is like, I like how the media is like, oh no, look at this guy. Does this look like a gang member? It's like, guys that look like that cut people's faces off. Like, yes, he looks like a gang member because gang members could look like anything. You can't have every single person look like they just came out of 3 prisons at the same time. Like some of the guys have to look normal to do drug deals or to drive people, in a car across state lines for whatever purpose. But it's always how they look. And well, look at this picture in this photo. It's like, oh yeah, a photo of the guy with his kids. Well, yes, he's not lighting someone's feet on fire with a butane torch right now, but he's still a bad person some of the time.
So here's a funny thing. My thumbnail guy was making thumbnails for me. Every time I did an MS-13 story, there'd be a dude in the thumbnail who had the whole face tattoo, neck tattoo thing going on. And last week, my thumbnail guy calls me and says, hey, ChatGPT will no longer generate Hispanic-looking men with face tattoos.
I wonder if you can do like white-looking men with face tattoos and then just say, now give them a tan.
Oh, it was so funny. It was like, it will not do Latin-appearing muscular men with face tattoos. That was it. It's like, what? This isn't a gay bar in Havana.
I don't know a man who would not do Latin-appearing muscular men.
Do you have any idea what time they're supposed to be getting back and if there's actually going to be testimony later?
No, I watched from when court started this morning and they didn't say anything about when they would get back.
Mm-hmm. No, I was just catching up on that. I had a Verizon issue, so I started like at 10:30 and saw that there was no testimony at all. They just went, they just told the jury that we're going on The View, and I was like, I hope Whoopi and Joy Behar aren't there. And and then they just packed on out of there. A lot of people forget that in the Murdoch trial, it was when they went for a viewing. They went for a viewing in the Murdoch trial, and that was one of the occasions. There was all these issues that came out after the trial had concluded. There was all these different issues related to the clerk who was in the middle of writing her own book about the guilt of Alex Murdoch, who was basically interacting with them on that viewing. So when they have that swearing in of the bailiffs before they go down there and bring them down there, we'll make it like it's a joke and like, okay, fine, everyone's swearing. I mean, the people just saying what they're saying, but there actually is potentially issues that can and have arisen in the past, certainly in other jurisdictions, if not in this one. And the fact that they're making an oath about it actually could have repercussions if they end up violating that oath. So in that sense, those pro forma activities they undertake are actually have some sort of level of significance.
Hey guys, so my feed from the courtroom, the ceiling fan had turned off and it just turned back on again. So maybe something will happen imminently. Who knows?
So I have to do the worst thing ever. Actually, it's not the worst thing ever. I'm just annoyed because I was late to the stream and it had tech issues. My Lady Rackets is out right now, and I have to drive one of my kids to an activity real quick. I'll be back as fast as possible. It's about 15-minute round trip. So
No worries.
I'll be back in just a minute. Joe, it's great to see you, brother. I hope to see you a lot more really soon.
Indeed. Awesome. Great seeing
See
you.
you guys in a sec.
All right. Doesn't he look like way healthier now? This is so good. I'm loving watching. I watched the two of you a couple of times, and he looks like much better.
He looks better than this.
Yeah, a lot better.
Yeah, keep my
Oh, I lost him.
keep my fat, beautiful body on screen. No, I'm just kidding.
So how you?
Hey, now that Joe's here, I would just like to remind everyone, go open up another window. Make sure you have Joe's YouTube channel open too, and subscribe. That's why we're here, folks, because we live off of subscriptions. They are tasty. I'm getting close to 200,000. Pop it up right there. I'm only 1,906 away from 200,000, and at 200,000, I will do a live no tie based AF live stream for all of you in appreciation.
Oh wow!
So go to if you're watching on Nick's channels, you should do that. But open up another window, go to lawofselfdefense.com on YouTube, hit that subscribe button like it is John O'Keefe, and you are a drunk ass Karen Reed driving a Lexus in a Boston blizzard, and then do the same with Joe's channel. Where can they find you, Joe?
At Good Logic. I'm on YouTube. I'm on Rumble. I'm even at goodlogic.locals.com. Spelled LAWGIC. It's like Lawgic. Get it? See, Good Logic. And there you go. And you can find me on X. You can find me at The Following Pro, just to be difficult. That's what that. Yeah. You have a similar thing where you have Law of Self-Defense some places and The Law of Self-Defense others. So like every time I'm like, wait, which one is it over here? But
so when I got on Twitter, which was 12 years ago now, when I started my Twitter account, they wouldn't let me use the word "of" in Law of Self-Defense. So on Twitter, it's just Law Self-Defense. I don't know why. I've looked at it since, and now if I wanted to create that handle, I could.
I think you can change it. I changed.
Can you?
I used to have Good Logic. What ended up happening with me was I had Good Logic on X, and then there was all sorts of family issues because basically no one in my personal circle of people was supposed to be able to like know what I do for a living, because that would be bad from societally. So I ended up, and my wife wanted me to just kill X altogether. She's like, you said so many things on X that I'm embarrassed. No, it wasn't even a matter that she was embarrassed. It's a matter that at the time my kids were looking to get married, and it was impacting them. It was in my social circles, like how the parents are and who they are is a big deal. And people would do research on me, and basically they'd be like, no, I'm not dating that guy's kid. I'm not having my kid date that guy's kid. And it bothered my wife. And I was like, all right, well, they're losers. They're idiots. I don't care. But my wife was freaked about this. She was really outraged, and she wanted me to shut down X altogether. So I ended up saying, okay, this is what I'll do. Since the name Good Logic is associated with me, on X, I'll change the name to at The Following Pro. The upside of this, as why I'm telling you this now, is I ended up changing that same account, didn't lose any account holders. I just changed it from what it was from Good Logic to at The Following Pro, which I picked that because I have my show at night called The Following Program, where I have my nightly live stream. So the following program didn't fit. So it's just The Following Pro. And Yeah, but I recommend to you, you definitely should grab that before someone else does.
So I just tried to change it, and when I add of it, I go over the 15 character limit for.
Oh, that's the problem.
Yeah.
That's the problem. Okay, that makes sense.
Here's a super chat, a generous one to me, $20. Thank you, Robert Norwood. So this is a general thank you for everyone. Just keep sending the money here. You can thank everyone, verbally. These trial streams giving me plenty to listen to while I'm working for the foreseeable future. Yeah, I'm also working for this foreseeable future, by the way. I had my last kid at 50. I'll be working forever.
It's no joke what you're saying, by the way, as far as these trials, that the reason I stream these trials is not for the views or for the super chats. It's purely for my own channel's viability, because YouTube hates me and invariably will pull 20 to 40 people away from my channel, unsubscribe them every single day. And it's impossible for that to be organic. That never happens. But to any channel, unless they're literally, and people tell me they get unsubscribed all the time. So I was at 102,500, and just after the last trial I did, and then since then I've been slowly drifting away till now I'm barely over 100,000. I've lost over 2,000 subs since that trial, and that was the Alec Baldwin case, and I never grow. I just lose and lose and lose, and then I'll have a trial and I go back up. So the only reason I do these trials is literally so I have a channel, because if I don't do a trial like this one, it's like my channel ultimately will just wither away in atrophy into being nothing. It's ridiculous.
If I were you, I would blame the Jews.
I do. It is. It's all the Jews' fault. Yeah. So I'm not asking for money, but I am asking for your subscription. So
that's why we're here, folks. That's why we're here. Let's see. I keep going up. It's very slow. I have to say, it's not quick, but it goes up a little bit at a time. We just hit 100,000 in New Year's Eve.
Wow, that's great. That's
I was stuck at like 50,000 for like a decade. It wasn't going anywhere.
No, dude, you should have 1 million.
That's my goal. A million. That's what we're looking for. So I'm 19.8% of the way there right now.
There you go.
Stegas, $5 says, have you considered Chattanooga for your Tennessee move? My brother lived there for a few years and he loves it. We've considered Nashville, not the city, but the suburbs, Brentwood and Franklin, south of the city, and Knoxville. We haven't looked closely at Chattanooga yet. There's certain attractions. Well, I have 2 young kids who are in school. So the most important thing to us is the quality of the school we can get them. And we found some really good ones in the Nashville area. So that's definitely possible. Knoxville, we're not sure yet. We have to go visit schools there. I'll take a look at Chattanooga. And there's advantages to living, in a wealthy suburb of a large city. There's a big airport right there. There's nice restaurants to go to. You're not actually in the city, so you don't have to deal with all that nonsense. So it's probably 90% chance it'll be Brentwood or Franklin outside of Nashville. But we're not committed. We have another year, so we'll be moving in about a year.
A lot of Jews moving there also. You can move in with Ben Shapiro.
He went to Florida, I think.
Oh, did he?
Daily Wire went to Nashville, but I think Ben himself went to Florida.
Oh,
I hear this. There may be a Jew or two in Florida too.
There may be. It's possible.
I think for Ben, it's like, well, your situation is much the same. He wants a substantial Jewish community for his family to live in.
Yeah. You need to have. The reason why we tend to congregate into communities, Orthodox Jews specifically, not irreligious Jews, they'll go anywhere, is because for religious reasons, we need to have like 10 men for prayer 3 times a day. And that means you need to have much more than 10 men, because not everyone's going to be coming at the same time. So you need to be living in groups of hundreds, if not thousands, if you want to be able to have that and have a normal schedule. And plus, you don't have to get kosher food and have that brought into you. You need to have enough of a community that's commercially viable, that you can have food there. So these smaller communities, they'll get like shipments of food every once in a while, but it's a much different lifestyle than what if you're living in New York. You're used to there's so much of a Orthodox Jewish network here that anything that you might need, you can find. Outside of that, you move to smaller areas, it becomes more and more difficult. So that's why we tend to congregate together, because it's necessary for religious reasons. But, yeah.
All right, here's a super chat. I think from earlier, Nick and I were talking about computers. Oh, no, Nick addressed that one. I clicked the wrong thing. Of course, I clicked the wrong thing. Misogyny and Mac worship. Misogyny? Misogyny? There's no misogyny. What are you talking about? There's no misogyny here. You're crazy.
Powered by child support. Full custody, women's shelters, child's tax care, OnlyFans, Sims, not drafted, shorter jail sentence, favorable court rulings, and vast community support. Yeah, it's much harder to be a woman. You have to deal with all of those headaches. All of those headaches. That's great. That's really great.
Using a Mac is like bowling with bumpers. Yeah, okay. I don't want my computer to be hard for me. I want to focus my energies on things that make me money, not fighting with my computer. Let's see. Here's one. Parathion, $5. During the first trial, Jeff from Legal Vices always referred to the ceiling fan. They're talking about this ceiling fan from the Karen Reed courtroom, where they pan the camera by default when they want it off of things. He referred to the ceiling fan as Ceiling Dion. So we should keep the tradition alive. Rip Lawrex. Indeed, I miss Jeff terribly. Great guy.
We all do. He was amazing.
Let's see if there's anything else. Most of these. Oh, here's one. I can't. Why am I getting so many? Not cupcakes, $20. Thank you very much. The most cringe text messages are yet to come. Wait until ATF agent Brian Higgins testifies. He was trying to bang Karen. His texts make me want to hand in my man card. In all fairness, she did reach out to him. Of course she did. Come on, we all know Karen Reed.
Yeah, she did. You were watching yesterday, obviously. That text exchange. Oh my God. I was sitting there and I was just like, this is a conversation every man has had where they're like, all right, just leave me alone. Stop pestering me.
Who is your next witness?
You're on the call. We'll call Dr. Gary Fowler to the stand.
Thank you.
We're back. We're back.
I got my own thing here.
Dr. Fowler, his expertise is like blood analysis stuff. He's probably going to give blood alcohol analysis of Karen Reed.
Swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God.
Sure. Witness number 9.
Good morning, doctor.
Good morning. Good morning.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Dr. Gary Fowler, F as in Frank, A-L-L-E-R.
And what is your occupation?
I am a physician pathologist.
And where do you work?
I work currently at Signature Healthcare in Brockton.
And how long have you worked at Signature and in what capacity, sir?
Signature, I started, it's probably 6 months. I took a new job 6 months ago. I am the chief of pathology and the laboratory medical director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015, late 2015.
And did you work in any capacity similar to that prior to working at Good Samaritan?
Prior to Good Samaritan, I worked at the Kearney Hospital, which is in Dorchester. Started that job in 1996. So I stayed on staff at Kearney Hospital up until actually closed 6 months ago. So I've been on staff at Kearney's for quite a long time.
Where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in '87. From there, I went to Tufts Medical School and graduated in 1991.
Following your graduation, where did you go from there?
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
And then where did you go following your residency?
And right
So
from
this is
residency,
actually the
I
first
spent my
appearance of
first job was at
Prosecutor
County
Lally,
Hospital,
Adam
which
Lally, in this trial so
previously
far.
mentioned, so 1996.
And
It's very
doctor, are you
popular.
board certified?
I am board certified in anatomic pathology and clinical pathology.
And what is a board certification?
Board certification is something we need to show that we are actually qualified to perform our the job that we need to do both in anatomic and clinical pathology. It's a written exam that we take and we need to pass to demonstrate that we're competent and know what we're doing.
First, in just general terms, if you could explain to the jury, what is pathology?
Pathology is, well, there are two basic branches of pathology: anatomic pathology and clinical pathology. Anatomic pathology is basically, an anatomic pathologist is a physician or MD or a DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made, and we every day make the diagnosis of, somebody has a cancer or somebody doesn't have a cancer, benign. Look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office, any sort of biopsy. Clinical pathology, on the other hand, is basically a clinical pathologist is a physician, an MD or a DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
And so the time that you worked at Good Samaritan, did that cover the date of January 29th, 2022?
Yes.
And again, what was your title and what was your job at Good Samaritan in the month of January 2022?
I was the chief of pathology at the time and laboratory medical director.
What did you do as the laboratory medical director?
Laboratory medical director, basically, the laboratory medical director is responsible for the ultimate quality of any, either whether it's a biopsy, somebody's biopsy, or lab result. The laboratory medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place, as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So as many, there are policies for competency for all the lab techs and phlebotomists and even pathologists. So basically, the laboratory medical director, if something goes wrong, it's ultimately his or her fault.
And the lab at Good Samaritan, is that lab accredited?
Yes, it is.
And by what body?
We are accredited, or Good Samaritan is accredited by the, we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus years or so.
What is accreditation? What does that mean?
Accreditation is basically something that says that your laboratory is following guidelines in providing excellent quality. To be accredited with the CAP, every 2 years we have a laboratory inspection. They don't tell you when they're coming. They will give you a 3-month window, and they'll come and inspect you to make sure we have a good quality lab. Each section of the lab, pathology, the clinical lab, microbiology, chemistry, hematology. The CAP has a checklist with numerous requirements that one needs to fulfill. There are probably over 3,000 items that they look at.
And was your laboratory at Good Samaritan, was the accreditation up to date on January 29th, 2022?
We were accredited, still are.
Now, in Good Samaritan Medical Center.
Does the microphone have to be in his nostril? Is that a requirement of the court?
Apparently. Lab testing for.
Did you get this guy's name?
I think the most common test
Gary Fowler, F-A-L-L-E-R.
performed
Thank
when
you.
you go and you have your blood tests is one is chemistry, a chemistry test where we sodium, potassium, chloride, glucose. We also a common test is a CBC or a complete blood count. Where we look at your red blood cells and your white blood cells and your platelets. Those are the two most common tests.
And why is blood testing ordered in the course of medical treatment at a hospital?
When you're admitted to the hospital, usually you're sick, so the physician is usually a standard, ordering chemistry and CBC to see if there are any clues in those tests that could help the doctor take care of you. If they look at a BUN and creatinine, maybe if they're elevated, you either could be dehydrated or have renal failure. If you look at liver function tests, maybe there's something wrong with your liver. So it's just a general a good look at the patients. To see if there are any clues that could help them.
And as far as the blood testing results are concerned, how does that assist either a doctor or a clinician in treatment and diagnosis?
Basically, what I just said. If there's nothing, if the
They should have a button like they have for Netflix when you're watching a series and you can skip the intro. Just go right into the show.
Just stipulate it out.
Hemoglobin and it's low and patient's anemic. Maybe the patient might need a transfusion. So there are many different case scenarios where the results can help the provider, the clinician.
Now, with reference to alcohol, does the Good Samaritan Medical Center, do they also test alcohol within the blood?
Yes, we do.
And why would that assist medical treatment and diagnosis?
I think if a physician is wanting to know if somebody's been drinking or has alcohol on board, or maybe not, maybe that patient has ingested maybe drugs of abuse. So they'll test for alcohol to see, one, if it's positive. And if it is, then it helps confirm that the patient has been drinking.
Now, are there any policies and protocols at Good Samaritan Medical Center with reference to how blood is taken and how blood is tested?
He really is a heavy breather.
Yes, we have numerous policies. We have one policy specifically for phlebotomists. Those are laboratory technicians who draw the blood. So we have a policy for them to explain exactly what they need to do. And also in the laboratory, we have numerous policies basically for any tests that we provide. And so we have a policy for alcohol testing as well.
May I approach the witness, Your Honor?
I have looked at North Idaho, but we need good schools for the kids. They're hard to find in Idaho.
Just ask you to review those generally and look up when you're finished. And do you recognize what those are, sir?
Yes.
And can you explain to the jury what is contained within each of those two sets of documents?
Okay. The first one is a patient preparation for specimen collection. This is the policy that I was mentioning, specifically designed for our phlebotomist to detail the procedure of the blood draw. Basically goes through one of the most important parts of the process is correct patient identification, where we need to correctly identify the patient. We have the patient state his or her first and last name and state it out loud to make sure it matches which the patient that we're trying to draw. And then we also match up the bracelet to the medical record number on the patient's bracelet. So one of the most important things is correct patient identification. The rest of this policy goes on and just pretty much details what to do next, including finding the veins, cleaning the site. So it has some information on if there are any complications. So it's basically the entire process of the blood draw. The second one is our alcohol policy, which pretty much details in detail what goes on behind the scenes for an alcohol blood test in our hospital.
May I approach again, Your Honor?
Yes.
Your Honor, Caldwell, so you can introduce in a minute the next two exhibits.
All right, thank you.
Your Honor, for the record, it would be the patient preparation for specimen collection, would be the next exhibit in line.
Submitted as
And
exhibits.
the ETOH policy would be the next exhibit number 37. Now, doctor, what types of precautions are in place of Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could
Everyone's drunk.
cause a false positive. So we have in our policy, and every hospital should have the same policy where we use a swab, a swab that has no.
That person in the background looks like the
we
Secret
call
Service
them,
agent from
a
Trump's
moist
assassination.
towelette. That's what we refer them to.
She lost some weight.
Also, in the emergency
Not much,
room,
but a little
my
bit.
supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case a phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So
When were the alcohol swabs removed from the emergency department?
it was before my time.
Fair
I'm
to
not
say
sure.
prior to January 29th, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained.
That's not what I would have
competent,
guessed.
and know what to do when they draw a patient's blood.
What kind of
Imagine
training
this
do
guy's leather
phlebotomists
chest
receive at Good Samaritan?
bondage gear he wears at parties.
When I hear from
We try to
phlebotomist,
hire phlebotomists who have been trained. It's just easier. So they can have a high school background, but if we train on site, they just need to be trained on the proper protocol, proper procedures, and demonstrate competency.
Is there any sort of proficiency testing related to phlebotomists at Good Samaritan?
There's no proficiency testing for phlebotomists, but there's competency assessments. So with phlebotomists or any laboratory technician or even pathologists, there are strict guidelines for competency. We have to always make sure people know what they're doing. And it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are, one, initial training. You can't let anybody come in on their, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And then the law says 6 months from that, we do another competency assessment where we look at 6 elements of competency defined by CLIA, and 6 months from that, 1 year from the start date, is another competency, and then after that, it's annual thereafter. And that goes for phlebotomists, and that goes for any laboratory technician.
Doctor, once the blood is drawn by the phlebotomist, what happens then?
So the phlebotomist will draw it at the time. They need to have the specimens labeled in the patient's room, because you don't want the phlebotomist to mislabel. So everything gets labeled at the patient's bedside with an initial and with the phlebotomist's initial and date and time. That blood test will then be sent to the lab. In this case, the blood was drawn in the emergency room, so it gets packaged into a plastic bag and sent in a tube up to the laboratory.
And once it's sent to the laboratory, what happens with the sample from there?
Once we receive it, it's called receiving the specimen. There will be a technician who then goes into the computer, enters the phlebotomist's name from the tube into the computer system, enters the time, and the technologist will look and see what was ordered, and then do the appropriate next step based on what was ordered.
And in a case in which alcohol is one of the items that are ordered, what is the next step as far as the testing goes?
So the next step with alcohol testing, we use a specific tube, so the phlebotomist would know what tube to use. It would be a light green tube.
It's just a logo.
Lithium heparin in it.
Yeah, hey, what's up, guys?
We don't want the blood to clot.
Sorry, Nick didn't know what it was.
So that's why we use an anticoagulant. So the first step when testing for alcohol is that the test is designed to be performed on serum or plasma. And to get that, the next step would be to centrifuge the blood. A centrifuge is...
you got background noise, Nick.
Yeah, we're getting feedback.
Oh, okay, I'll mute. Hold on.
Spin it at around 3,300 RPMs, which is...
I'll mute unless I'm going to talk.
Rotations per minute. And the reason why we spin it, because centrifugation will allow it to separate the blood components based on the density. So heavier stuff like the red blood cells will go to the bottom, and the lighter stuff like the watery component of the blood will go to the top, and some of the white cells go into the middle. But for alcohol testing, we are targeting the top part of the blood component, which would be plasma.
And then once it goes through the centrifuge process, what happens then?
So once it's centrifuged, we have the separation of the blood components. We have the plasma ready to be tested, so that technologists will walk the specimen over. It's probably 10 feet from there, and put it onto our Roche Cobas machine. That's our machine that performs our chemistries as well as alcohol testing. It goes on to a machine. All the testing is basically inside of a black box. And the label present on the blood tube will dictate what the Roche machine will test. So based on the barcode label, once it's on our machine,
Roche, a good German company.
Knows what test to do, and it will
Roche
perform
Diagnostics.
an alcohol test.
And Doctor, for our stenographer, do you know how to spell that Roche Cobas machine that you were just referencing?
So ROCHE, Roche, and Cobas, COBAS.
Thank you, sir. May I approach, Ron?
Yes.
A lot of times they want to go through the qualifications the guy has extensively, so the jury has more trust for them, even if they want to.
I trust this guy's qualifications just because of how bored I am listening to him.
Do you recognize those records, sir?
Yes.
And what do you recognize those to be?
These are the medical records of Karen Reed.
And sir, is there an indication within those records as far as the date of treatment for Ms. Reed?
Yes, there's a bunch of dates in here.
As far as the treatment is concerned, sir?
Yes.
And what is the date of treatment?
Oh, 1/9/22.
Sorry, is that 29/22?
That's what it says on this.
Should have gotten it in Braille. Rookie mistake.
What's he doing?
Admit date, it says 1/29/22.
Hey, law self-defense members, I'm starting to put your comments at the bottom
Doctor,
of the
if
screen.
I could direct your attention further into the document to a previously tabbed portion, do you see any indication in there as far as a result for alcohol testing?
What the hell? It's close.
Like, I know the guy
Sorry.
just needs, I don't know what he's. It's always funny when like a
Yes, I
tech
do.
guy gets on the stand, does something weird, like punches over the reading like
With respect
that.
to Result. Have you reviewed these records prior to today?
Yes, I did.
And if
Looks like a
you
mad
could,
scientist.
Explain to the jury sort of the timeline from this blood sample as far as, let's start with first when it was ordered.
So when it was ordered, it was 9:03 in the morning.
And when was it
Okay.
taken, sir?
The blood test was taken 5 minutes later, so 9:08.
And then what happened, or what is the next time that something of any significance happened with it?
5 minutes from that, 9:13, we received it, and 9:53 in the morning, the result was entered into the computer. So it was ordered at 9:03, and I believe it was 9:53. The results were in the computer.
And may I approach again, Your Honor?
Yes.
I'm welcome to seek to introduce and admit as the next exhibit.
Any objection, Ms. Little? Objection. All right, thank you.
Oh, I guess Little will do the cross then. That'll be nice. We haven't seen her yet.
Your Honor, may I return to the-
On cross, sir, what percentage of blood samples go missing on a daily basis while you're taking them in?
How many do you personally consume?
And Doctor, what was the result of the testing for alcohol in the defendant's blood when it was taken shortly after 9 a.m. on January 29th?
When I drank it, I got
93
drunk.
Milligrams per deciliter.
Thank you, sir. Nothing further, Your Honor.
Ms. Little?
So we're just here for the report.
I'm going to pause it for a second because Nick managed to talk over the blood
Nothing further.
alcohol level.
Per deciliter.
On January 29th.
93 milligrams per deciliter.
Okay, there we go.
Nothing further, Your Honor.
Little. Come on, baby. She got her nails done today.
Does that mean anything to you?
Good
93
afternoon,
milligrams?
Dr. Fowler.
Oh, good afternoon.
They'll
The
translate
Good
it.
Samaritan lab is a clinical
It should be on
lab,
direct.
not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say 99.9% of the time we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common. I think uncommon.
And you'd agree that there are differences.
Did you say I think I'm common?
between conducted in hospitals and forensic
uncommon.
tests that are conducted by law
Ram.
enforcement, right?
Yes,
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
No.
But you've never been accredited by a forensic accreditation team, right?
No.
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
Are you aware that ANAB is the forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court?
Sustained.
Now, the
Assumes
most
fact, not evidence.
reliable method of forensic ethanol testing
What was-
is called headspace gas.
What was the objection?
Gas from HSGC.
I think it assumes facts, not
Are you
evidence.
familiar with that process?
Yes.
She just asked if he was aware of that.
And HSGC is the method that's used by forensic labs to test
Would you
for
agree
blood
or
alcohol,
disagree?
right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out all red.
Delicious.
That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood. That is the specimen of choice for forensic blood ethanol testing.
Specimen of
Hospitals, on the other
choice.
hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't, that's what I went when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we test we tested on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, doctor. Thank you.
Okay,
I'll
all right.
ask some additional questions
Okay.
to kind of clarify. And in a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
You did your test in your kids, 10th grade
And that
kids.
clinical chemistry machine
home lab.
performs what you just testified to, a serum test, right?
Serum or plasma.
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy to automate, but at the same time, very, very good and very accurate.
It's
But
good though.
Serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that. Alcohol testing in the lab is correct.
I'll ask you some additional
Okay,
questions
sure.
about NADH and we'll
Sure.
get there.
Yeah.
You'll get there, buddy.
So
Calm down.
You can do this.
Take
now,
it slow.
but let the doctor answer his question fully. Next question, okay? And the following questions.
Doctor, the
But he
higher
did answer the
NADH
question.
in a patient system, the higher the serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's also very good and very accurate.
He's not actually going into it.
When we compare our methodology to the headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this. Maybe some of you might.
How long does he get to just exposit?
But we do. We take the patient's sample, and it's based on. We
Can you
add
adjust Nick's volume down a little bit?
because
I don't know. Can I?
when there's alcohol in the specimen.
I'll be back
we
on camera in
add
just a
actually in
couple
the test
minutes.
system, alcohol
Edit? Okay, I
dehydrogenase
see.
is the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system,
Thanks, Joe.
it's alcohol dehydrogenase is in there. And what happens is when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline. And we use, there's something that measures, and a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers. And it's pretty accurate. It will monitor, it will tell you, give you a,
Pretty
it will
accurate.
tell the system
Worthless
how much
statements.
NADH is produced. And that amount is directly proportional to the alcohol in the patient sample. So it's a very, very accurate test, but there are some limitations that I can go into.
So wait for another question.
Pretty accurate. Doesn't sound like reasonable
Serum
doubt.
testing can be subject to errors, right? Subject to errors, right? And there are limitations. There are
some limitations that I can explain, just like head-space gas chromatography may have some limitations too. But
Jurors don't know
go into them.
Yeah,
what
next-
spectrometry is.
What are some of the limitations
Of
of the serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is icterus, which is high bilirubin. And the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose-Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols?
All right, be right back down to my office.
And third is there's some unusual hematologic malignancies like Waldenstrom's macroglobulinemia that can interfere. So it's always have to correlate with the clinical situation. The next one, sometimes there can be patients who make endogenous make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own, so we have to rule that out. It's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid, those one is an enzyme, and the other one is an acid. That can cause false positives. Now,
if I could stop you there, doctor. I think those were the four that you identified, the four limitations: the lactic acid, the hematology.
Yeah.
If I could just
Go ahead and ask your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Fowler, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid or LDH actually forms NADH. Right?
Lactic acid, I'll have to go into a little bit of chemistry. Lactic acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s, when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH studies have found can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Assumes fact, not evidence.
Are you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based.
Let him finish his answer.
It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change. And it basically, back to the anemia, I haven't read or heard of that.
That was stricken. That was not allowed.
It all goes back to the lactic acid and the LDH. The NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study, maybe 7-10 years ago.
Your Honor, there's no question pending.
You asked him about a study, if he was aware of the studies.
I asked, and that's a yes or no question.
Yeah, she's just.
All right.
The judge is just letting him ramble on these long things without any questioning going on at all.
Doctor, have you reviewed the August
I think most of the
21st,
biochemistry
2013
conversation
peer-reviewed
goes over the
article
jury's
entitled
head.
Serum NAD through disease course in multiple sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales. Which, sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
To what? What's the objection?
I'll strike the part of what the article held. Is he aware of the article?
No, I'm not, to be honest. No.
I think
Dr. Fowler, did you consider Ms. Reed's anemia and multiple sclerosis condition when you conducted the alcohol test on January 29, 2022?
No, we don't. No.
And again, serum tests like the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Doctor, you did a number of other tests on Ms. Reed on January 29, 2022. You tested for additional drugs, not just alcohol, correct?
Correct.
And all of those results were negative.
Correct.
Thank you. No further questions.
Okay.
When it's that technical, it's more important to look like you're winning than to actually win. Because that's what most of the jury is probably not going to understand a lot of what was just discussed. But if you look like you got some hits on him, whether or not you did is almost more important than actually getting the hit.
Doctor, are you aware?
We got them 34 nanometer
Good Samaritan did not do
spectrometry
this process, but are you aware through your training and experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to a blood alcohol concentration of whole blood?
I'm going to allow it. The door was open.
By what? He should have done this on direct.
Yes, I am aware. Yep.
And please describe what you're aware of with reference to that.
Well, with blood alcohol,
.093. That's all you need to know.
goes to,
0.093.
when it's in your blood, it goes more to the watery components of your blood. So when I described the process,
The ones that are
earlier,
removed in the
whole
plasma
blood
serum
is
testing?
before we spin it. And when we test the plasma, which is specifically testing the watery component. Now, people have done studies like how much percentage of water is a serum versus whole blood. Basically, to put it simple, there's a higher percentage of water in the serum versus whole blood. So a hospital result will always be a little bit higher than a test on whole blood. It can be, I think the ratio, the conversion factor is anywhere from 1.1 to 1.18. It's always could be 18% or 11% higher in serum versus whole blood.
But that puts you
But we
below
don't
the
do
legal
it.
limit if
That's
it can
what
be
I read.
18% higher.
We'll defer that to the experts.
Now, doctor, you were referencing in your
That's kind of fucking
cross-examination
important.
about a study that you were aware of about 10 years ago or so regarding MS and alcohol testing. Is that correct?
It was more on MS, looking at the results of lactic acid and LDH to see how high the levels of lactic acid can go in a group of multiple sclerosis patients. When reviewing that, we found that the range went from some normal range, 16% of the multiple sclerosis patients had normal lactic acids, but the remainder had elevated levels. But those levels were not anywhere near the required levels to produce a false positive. Our package inserts and for the Roche testing system, the Roche has, it's an FDA approved test, and they have to do in-depth, detailed testing before they allow any hospital to do a test. And they have listed, levels of lactic acid beyond which the test would not be reliable. But the results, based on this study of 600 multiple sclerosis patients, 2 big centers in Italy and 1 in the Netherlands, show that the highest level of lactic acid in the MS patients did not achieve, didn't get close. Usually patients with MS that are asymptomatic can have normal or low normal levels, or slightly elevated. It was the ones that had more symptoms that had elevated levels up to, I think the highest was 6.5 millimoles per deciliter, which is not high enough to interfere with our result.
Now, with respect to the lab at Good Samaritan Medical Center, the interference that you were speaking about earlier on cross-examination, what would happen if any of those types of interference were to occur during the course of the testing?
No, I'll allow it.
The 3 main ones, which I detailed earlier, is the hemolysis, icterus, and lipemia. Our machines are sophisticated. It will detect it and say, it will flag it and say, please do not result it, or we'll have a disclaimer saying, interpret this result with caution. The results may not be accurate. It hardly ever happens with alcohol testing. But if it did, we would get a result like that, and we probably wouldn't report it.
And from your review of the defendant's medical
0.788,
records, specifically
by the
her
way.
testing from January 29th, did you notice any interference or any reports like that in her record?
No.
Now,
She could have
the
gone home and
testing that
drank
you're doing
a whole
at Good
bottle when she got
Samaritan
home.
is in relation to patients such as that might have cancer or heart disease or something like that, correct?
Correct.
Now, you were talking or started to speak on cross-examination about the good quality lab results that you have from your lab, and you wanted to go into that further. Could you please expound upon that for the jury now?
We have you mentioned proficiency testing before. So all hospital laboratories are accredited by the CAP or have to participate in proficiency testing. What that means is that every 3 times a year, and they give us 5 unknown samples. And we have to test it, report it back to CAP, which also reports back to the government. And we have to basically get the correct answers. And with alcohol testing, it's probably one of the best tests in the laboratory. Always have right on the money results. But at the same time, we're also able to look at results of all the other labs that participated in this proficiency testing.
How much money would this
So we
comment
can look at
save?
different methods. You can look at labs that had the same method as us to see how we're doing. And usually with this proficiency testing, we have 3,000 labs across the nation that have the same methodology as us, so we can compare to them. And also, interestingly, we can see the labs that are using headspace gas chromatography. And out of interest, we can see, how do we compare? And we have pretty exactly the same results on these proficiency testings. We also look at some statistics as well, not going into them, but we can look at some stats like standard deviations and SDs. And actually the hospitals with enzymatic testing have slightly better stats with that compared to Headspace. Pretty close, but a little bit better.
People think
Doctor, from your review of
drug and
the
alcohol
defendant's
testing is
medical
like this
records and the blood
magic
testing
button.
in this case, was that done in
Just
conformity
it's
with the
not.
policies and protocols at Good Samaritan?
We have policies in place to be followed, and there's no reason not to think that somebody didn't follow policy.
Thank you, sir.
Anything else, Ms. Little? No questions. All right, doctor, you are all set, sir.
Oh man, she should have gone back. An 18% higher result on a 0.093 blood alcohol content, 18% higher than the real number, comes out to a
another witness, Mr. Brennan?
0.0788, which is under the legal limit.
Jason Becker.
Their argument is that she's over the legal limit in alcohol, with blood alcohol, but she may not be. Like they used the wrong test, a test that would not be accepted if she tried to introduce it in her own defense. Like, sorry, this doesn't rise up to the level of our forensic laboratory specifications. But when the government wants to use it, they always can.
Looks like another cop.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall
Dude looks like he installed his required anal rod today.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live in Canton.
Tell us a little bit about your education.
My education, high school and college UMass. And I went to EMT school a little over 10 years ago and paramedic school.
Oh, that accent.
Tell me a little bit about EMT school. How old were you when you started EMT school?
This guy's eyes are more
I started
sunken than
EMT
mine were.
school, roughly 21 years old.
Why did you decide to go to EMT
He test this
school?
guy right now.
Wanted to save some lives.
Tell us a little bit about EMT school. What did it require?
EMT school was a couple months of classroom stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's about a little extended, 2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
Oh, I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct.
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
On the Canton Fire Department. So I got on the Canton Fire Department, and then they send you to the fire academy. where
Look
they
at all
train to
that
be a
suppressed
firefighter.
anger.
So you had EMT training, paramedic training, and then firefighter training.
No
That's correct.
lips.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir.
department, sorry.
Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There's two.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is larger.
Had you ever spent time at Station 1 as a firefighter or a paramedic?
I have. We rotate through both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the two stations.
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine company with 3 guys on it.
3 people were assigned to the.
The engine.
I thought he was
Correct.
just being racist when he said that.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
What were your roles between the two of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time. So
he's the top.
He was there to teach me.
So would Dan Whitley be the lead on the call and he would help you?
I would be the lead.
You would be
And
the lead.
correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient, whether voluntarily or involuntarily, because they're a threat to themselves or someone else.
When you received the call for a Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're unseen first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant, who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
She was in
And
the
person you
murderer's
spoke
seat.
to who's in the passenger seat of that car. Do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
It's a crazy drunk broad at the table.
Navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
Oh,
At some point, did you
five.
and the defendant move to another location?
We did.
Where did you go?
So we went back to the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
She cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and firefighter Whitley.
So you and firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
I mean, each patient's different, depends on what the call is for. In this specific situation, it was more a psych eval, 'cause that's what we're called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are kind of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak in their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was gone dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there?
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Miss Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
At other times, did you speak directly to Miss Reed?
I have.
Can you describe her demeanor or temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't. She didn't.
They just must not have.
She just kind of said in jest because of the events that she went through. So she, but then there'd be periods of which she'd be calm, and it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
I'll allow that, Akima.
So one of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said. But that's what she said to me.
That the last thing she said to him was an argument?
Yep.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Thank you. I have no further questions.
Okay.
Well, thank God.
Who's on cross?
Now, what's on cross? Gosh, this guy looks strung out.
Yeah. He's stressed. I wonder if he's currently
Looks really
dating
nervous.
Karen Reed.
Pop 9 oxys in preparation for this testimony.
Afternoon, Firefighter Becker.
Good afternoon.
Alan Jackson.
When you first arrived at the
I love
scene,
this guy.
there was at least two Canton police officers there still.
Correct.
Do you remember their names?
Officer Saraf and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there.
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They'd cleared.
They had already transported to the hospital.
Remind me, you were in ambulance two. Or,
I was ambulance 2.
got it. You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door.
Correct.
Had a short conversation with her there.
I did.
You said it was maybe 5 to 8 minutes.
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment.
Well, it's more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well.
There was.
Female, male.
Female.
So there are two females, one Miss Reed, one another female. Did you see any other civilian females out there?
I didn't see.
Okay,
But
so at
This
least
guy's not
where
seeing
you
civilian
were,
females.
The contact that you had with Miss Reed and this other female, there's just two of them, not a third one.
from what I saw, correct.
Did you get the other female's name?
I not at the time I did not.
Okay. Have you, by the way, have you since gotten her name?
Based on a conversation Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who is that other person? That other
Miss
female?
Carrie Roberts.
Okay.
So he didn't see Jen
When
McCabe.
you first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did. Yes.
Describe that for the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
Well, she had said that she had given CPR to her husband.
Okay, you jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did. So that kind of, in a way, ruled it out. No
Okay.
injury for me.
And you didn't indicate, you didn't notice anything about her that looked like she was physically injured, physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth, attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck.
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that?
Correct.
Okay. You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma, as best you were trained at the time? Objection.
A little bit more of a foundation. I'll give it to you.
Sure. Have you ever, in your course of training, seen individuals who have gone through some sort of a traumatic event?
Frequently.
Frequently.
Everyone's different though.
Understood.
Usually
Obviously,
right
there's
after I
other
ask him for a phone
personalities and
number.
way of dealing with those things, right?
Sure.
Have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yeah.
Okay. Did it appear at that time when you're interacting with Ms. Reed that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So hence the rapid speech, the repetitive speech, things of that nature.
Correct. For her. For the defendant, some people don't have repetitive
Understood. I'm
speech.
just talking about your observations of her at that time.
Yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital. I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation.
Correct.
That's obviously of great concern to you and your partners when you're assessing a patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm, that I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, I mean, at the time I believed her because of the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault. At the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
So I couldn't rule it out, but
okay.
I didn't think it was a huge threat at the time.
Understood.
But we couldn't rule it out. So that's why, we had to take her to the hospital.
Understood. I mean, you had a section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Miss Reed, correct?
Not the entire time. He was before we started transporting. He was kind of in and out, trying to find more of, talking to the police officers, find more of a story of, what happened, why we're taking the defendant on a section 12.
Once you and Miss Reed were in the back of the ambulance, Firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was a couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Miss Reed, for the whole transport back to Good Sam.
Yes.
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
For the majority of the transport, yes.
Okay. Never became combative, never got physical, nothing like that?
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse?
That's correct.
You're aware of HIPAA rules, obviously. You're in the medical field, correct?
Correct.
You're aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or a child, there's certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars, right? Other hearings.
I have.
You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those on a tape recorder, correct?
I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, it could have been. I mean, it's kind of for every call, we jot down notes on like a notepad, just
Okay.
so when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
I gotta, to be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on
Okay.
at the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer, as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes I write on the computer, sometimes I don't.
Or you might.
Honest answer. Good.
Correct.
Okay. So in any event, you weren't taking down.
He'll be
you were
punished for
taking-
that later.
You weren't taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right. You had previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Miss Reed actually said to you was something along the lines of she was upset because her last words to him were because of her last words to him being in anger. I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrong.
No.
The last words, it was the last conversation.
That's a different
Okay,
thing.
that wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase "her last words to him"?
Yes,
were
I
in
did.
anger?
I did.
And that was at a hearing where you're under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
Grand jury, yes.
Okay. And the phrase that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said, quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
Yeah.
All right, can I see counsel at sidebar, please?
There's a very big difference because if you're in a massive fight versus just like one quick blurb at the end, it sort of changes the nature as to like, is she likely to be, running him over, which is what the state is accusing her of. So
When we read those, they read the text yesterday, and yes, they were having an ongoing argument, but none of it looked like violent animus towards the other. It doesn't look explosive. At that point, it looked fizzled out and tired. And it's like, let's just like, oh my God, this is still going. I thought you were going out for a drink. Now the guy's plumbing. Like, how long is this going to go on? It's not, okay, you motherfucker, this is the last time. Like, this is it. I can't believe you did this. Like, none of the explosive stuff we would expect.
She did come across as clingy. I mean, she
Oh,
texted
yeah.
him 400 times in the span of 3 minutes, called him, and he's like, stop calling me. I mean, she seemed clingy and afraid of losing the relationship. But that was earlier in the day. And then when he said he sobered up, he started being more welcoming to her. And it seemed as if, like, he said, I sobered up now. And his whole tone was, what, you're not going to be sleeping over here tonight? You're not coming? Like, he was still into her. He displayed signs of jealousy at the plumber coming, even though he was trying to, it seemed to me, at least, when I was reading those texts, that he was trying to mask it by saying, well, you don't need to waste money on a plumber. And that's what he told Mike Camerano. But it seemed, he's asking, is he sexy? He seemed like he was concerned about the male presence there, which is someone who's not looking to dump her. All these things are telling me he didn't dump her in the car there and her running him over. That's the thought I was taking. I don't know if you guys had a similar take.
Well, not just that, like with the jealousy stuff, it's like,
yes,
thank you.
All day you've been asking to hang out with me, and now we got to wait on the plumber. Like, it just annoyed.
The conversation that Miss Reed indicated that she was upset about. You also indicated, in addition to using the phrase her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
Just a moment, Your Honor.
Yes.
The other thing that keeps getting confused in the questioning of these guys in particular, did you say this? Well, that's not what she said. That's not the question. The question is, at grand jury, is this what you said?
May I approach?
Yes.
Not what you think now, not what she said, not what the prosecution told you to say about what she said back then, but at grand jury, you said
Mind,
this.
take a look
And they're
at
really
the
simple
top
questions.
Paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
May I approach?
Yes.
He finally got his case of amnesia.
When you wrote the report, you had indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct.
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
She said that.
Yes.
Correct.
Okay. Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she believed he ever received her last words to him?
There's no other details than there was no other details other than what she said.
Okay. But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay.
And she tried to, or she did?
Did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voicemails? Did you put those two things together?
I did.
Okay. Thank you.
I just want the jury to put that together.
Hey, Mr. Brennan.
He doesn't care about this. He's using the witness as a prop there.
So did the last four
So
women who
Ms.
spoke
Mead
to him.
told you that she was sad because her last conversation, or her last thing that she had said to him was an argument. Did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection.
Sustained.
This is insane.
You then were interviewed, weren't you? You
Yes.
interviewed on February 14th, 2022,
Yes.
and you referred to the fact that she told you there was an argument earlier in the night.
Argument early in the night.
And she was telling you this when you were speaking to her that morning.
Correct. Around 6 a.m.
Correct.
Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No,
or midnight?
I didn't know the time.
So his answer is he doesn't know.
You
Say some more
testified in
times,
the grand jury, and Attorney Jackson just asked you some questions about part of the statement you made to the grand jury when he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember
Her last words.
remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
So someone in the chat said are they all expected to have eidetic memories? No, they have a transcript from the grand jury. These statements were made under oath.
Yes, sir.
They can refresh the recollection of the witness. They can allow him to read it.
I would
Remember
ask to
this
be
now.
refreshed for every question. I don't trust my memory. Now show me the transcript.
Who remembers the exact words that they said 2.5 years ago for damn near anything? I mean,
They seem to
very unlikely.
Their memories seem to consistently make her look worse and worse every time. None of them make
Now,
her
when
look
you made
better
that statement
when
you were
they're
asked about in
saying
the
it the
grand
second
jury,
time
you
through.
didn't just say, like her last words, did you?
Well,
No.
they couldn't
You
get her to be
explained
guilty
your
last time.
memory to the grand jury?
Ask him what he told you.
The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay. And did you tell the grand jury
Are you telling me it was?
I'm going to see counsel at sidebar for a second, please.
I really want him to say this one thing, and he's just not doing it. He's trying clearly, like he's trying desperately to get him to recount some portion of the statement that he made that's on the page that he showed him.
Yeah.
But he can't say that, and he can't say, didn't you say this? Because he can't lead. Now, if he were on cross, he could lead him into what he said. You said this thing on this date. Isn't that correct? Yes, no. But on this one, they're like, how do we get him to read the thing we want him to read? It's great.
Subscribe, everybody. Law of Self-Defense on YouTube. What is it? Is it Good Logic?
Good Logic.
On YouTube and Rumble. And Rekieta Law on YouTube and Rumble. Subscribe, everybody. My mission is 1 million subscribers. I can only get there with your help. We're 19.8% of the way there. We can do it with you, with your support.
Almost as high as Karen Reed's blood alcohol content. Now, don't get me wrong, guys. I don't think she wasn't intoxicated. But the state can only prove what they can prove.
That statement that you made, that includes last words. But there's more to the statement, isn't there?
She was upset.
I'd like you to read
Oh,
your
sorry.
entire
Sure.
statement, 1 through 5. You can read that out loud.
So she was also she was upset also because she said they had, the last time they had talked, she had gotten into an argument. So she was upset that that was like her last words to him.
And so when you were speaking about her last words to him, were you referring to the argument?
Correct.
Which
You testified
argument?
again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
And at that point, did you think or believe that the conversation she was relating to you was about a voicemail? Objection.
I'm going to sustain the objection.
Did you use the
Already
word
asked the
again
question.
on May 3rd, 2024, argument?
Objection. I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
Your Honor, I know we've now had what, 2 sidebar. Oh wait, sorry.
Prior statement on page
He's just approaching the witness.
line 9 through 13.
Like he did. I won't say.
I'm going to see you at sidebar again and bring these documents, please. Bring all of it.
I didn't make any starred notes on what I want you to read to bring this back up to you this time.
Well, this isn't cross. This isn't impeachment. This is his witness. He just has to get the witness to testify. He can't get the witness to read off the grand jury transcript. What's the point of that? The witness is sitting here right now. If the defense was impeaching this witness, they could get him to read off the grand jury transcript as impeachment.
I'm curious what you guys think about Karen continually going up there for these sidebars. To me, I think it's weird, and I personally thought it was a bad look. I'm wondering if you guys think that it affects anything as far as, because I think it makes her look like she's controlling. It just is. It's an unattractive thing rather than just sitting there. We never saw Kyle Rittenhouse go up there. You never see defendants go up there. Like, they have to be involved every step of the way. That's why you have counsel. To me, I think it's the jury. It can only invite a negative reaction from the jury, and I don't see what positive can come out of it. I would tell her to sit her ass down.
That's why John O'Keefe ran his head so hard into the back of a Lexus.
Yeah. He was just
controlling me. No. I don't
think
know,
she's
man.
texting her lawyers like in real time through the whole trial. She's sending them endless streams of texts.
Oh my God. Oh my
Look, I feel like you're paying attention to your other defendants more than me.
Is there another defendant?
I don't know. On one hand, I see what you're saying. On the other hand,
I mean,
it's
I
really
wouldn't want
fucking
that.
frustrating.
I wouldn't want my client coming up the sidebar with me. That's weird.
Right.
What do they know?
But this is a retrial, and the first trial was a media thing, it's huge in the area from what I understand. Like this is in Canton, like, right. This is a big deal. I think if my life's on the line, maybe I do want to come up to every sidebar. Maybe I want to know exactly what's going on in the case. And maybe my own experience, the things I've said, the things I remember can be assistive in my defense. And I can't necessarily do that if my lawyers are hearing something and relaying it back to me as if I'm an idiot, right? And they do. They dumb down what happens at sidebar. They downplay what happens at sidebar because it's not really up to the client. Like the client's not the one who has to deal with all the shit that's coming out from the fallout. So from a lawyer's perspective, they summarize and truncate what happens. And of course, they're not going to have perfect memory of what everybody said. And then they go back to the clients like, well, this is what happened.
Yeah, but in this context, the client is an idiot.
I'm agreeing with you. But I'm just saying, like, if I'm in her shoes.
You're a lawyer. You understand what's happening at sidebar far better than 99% of all laypersons are going to understand.
Karen Reed just went through a first-degree murder trial. She understands more than most lawyers about what's happening at sidebars at this point. Like that crash course in education. I mean, not only did Karen Reed go through a first-degree murder trial, it was a 6-week-long, highly publicized first-degree murder trial with tons of analysis out there. Karen Reed knows a lot about the law now. Like, I mean, for better or worse.
Well, I don't think she knows about practicing law to the extent that she may not realize that her objective is to have the jury love her, and this cannot help. That's my point. It doesn't help, and it could hurt.
No, I agree, but believe me, I'm all about image in the courtroom. Like, for everybody except myself. But I can tell you it was frustrating watching my lawyers go into chambers.
I'm sure.
Sir, when you wrote the report of your notes to put in your report, did you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
You said that there was somebody in the front seat of the car with the defendant?
It was.
And you later learned from the defendant it was a person by the name of Kerry Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, firefighter Whitley, had a conversation.
Objection. I'm going to allow it.
So the defendant brought up how if her husband had died at the time, she didn't know how she was going to take care of his kids.
Objection. I'm going to allow this.
And firefighter Whitley mentioned that she had like a strong support system. All the friends are on Canton, and have
you met Kerry Roberts? This all hearsay.
All of it, every word of it. Didn't Whitley already testify?
Yeah.
I mean, that's the appropriate witness to talk about.
We already heard it.
Conversation. We already heard it, and
she's already testified. So now especially any statements that are brought up are going to be non-cross-examinable because she's done. I mean, I guess you could recall her, but the better way to deal with it is, sorry, you had your chance. You had your chance to get her testimony in. If you didn't do it, you can't do it through this weirdo. I think with that guy, never mind. I don't know. His eyes are creeping me out. Looks like there's that Nicolas Cage movie where he was an ambulance driver, kind of looks like that. It's like,
all I know is if I went to the dentist and my dentist had this guy's demeanor, I would leave. Like, this guy is way too angry to be a dentist. I want working on my teeth.
Helena Handbasket says, good to see you back in the light of day, Ricada. Thanks for covering this trial. Keep up the good work. Oh, here we go.
If only Binger was prosecuting. Binger.
Hi, guys. Testing this out. No female voices, Nick. Good seeing you guys.
Well, I'll have to get some female voices on there. I don't know. I don't know what female voice I would put into the AI. Like every time. It's like, why would I want to choose that?
Hey, no, shut up and fix your mic.
Sorry. Jesus.
How is EMT testimony not HIPAA violation?
So HIPAA violations are often misunderstood. The information that is gathered has to be protectable. The information that is being shared and who they're being shared to has to be like specifically violative. Everybody just says HIPAA because medical information is involved in some way, and that is the HIPAA statute is much less broad than that. That's the easiest way to describe it. But here's the thing: your HIPAA kind of goes away in a murder trial. Period. Like that, you do not have a protectable right in your medical interest. You know, there may be some things about your medical history or condition or whatever that at a trial could be reasonably protected in specificity to address a specific concern, but not when you're the defendant in a murder trial. Like your mental health state, no more HIPAA. Like if you're crazy, they need to know, and the jury needs to know, and you're going to talk about it. But like there are protections to keep people from public embarrassment, but Karen Reed is well beyond
And if
that at
anything,
this stage.
she would want to share it, right? I mean, it's her own benefit. You can always waive your
Yes.
HIPAA protections, and she would want them waived for the purposes of having the jury giving her some sort of a positive consideration. So.
Oh, go for big guy says Dr. Mommy Rackets. Come on, man. Yeah, okay. A Dr. Muffin's voice would be good from the Johnny Depp trial.
Yeah, but the point I was making earlier about how their memories all seem to just make her look worse is if it was completely neutral, you would think that some would make her look better, some would make her look worse. Now, it's true they've all been prepped by the state, and the state is going to basically encourage them, push them towards making her look worse.
Not at all. State wouldn't do that. They're very neutral arbiters. They're not supposed to be. They're not supposed to be neutral. Sorry.
When you spoke to the defendant and she shared with you that her last words with her husband were an argument, why didn't you ask for more detail about that?
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Karen and ultimately get to the hospital safely.
And you were asked about trauma, and you said that you observed that the person may be in trauma, Ms. Reed.
A traumatic event,
Traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything?
Very briefly, you indicated that you were asked on redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the night could have been 6 o'clock p.m.
Early in the night, yeah, correct.
Could have been 5 o'clock p.m.
Could have been.
Could have been 7 o'clock p.m.
Sure.
Okay. You were also asked.
I can do
whether or
times
not
two.
Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't,
That I remember, correct.
but she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you. That's all.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. Jurors disregard that last statement. All right, you are all set.
Thank you. Thank you, guys.
Is this a good place to stop for the day?
Oh, wow.
The court pleases, yes.
Yeah, I
We
think
could do 6 minutes, but I think this is probably a good place to start. So, as I understand it, folks, we're on schedule, right where we thought we would be. We're going to release you for today. Now, when I told you this
lady
morning,
looks
I
like
told
she's
you
going to tell me where the best bars are on the beach.
when you were out in that room waiting for us, we're in here getting work done to make things more efficient for the trial, especially a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So Monday for you will be a half day. All right, so I just wanted to tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case,
Please disregard it, let us know, and I guess the fourth caution is the same as I've been saying. Please be very careful with your social media. All right, have a good weekend. We'll see you Monday morning.
All right, for the board, please.
And I'd like to see counsel at sidebar, please.
You're all in trouble.
I'll keep the audio up for me, but I'll pull that down in case something happens.
Oh my goodness.
So another early day. That's nice.
Yeah, she indicated today would be a half day, but I mean, I feel like every day for her is a half day. I'm not sure how there she is. She got to get real active there at the end. They, a lot of sidebars, so the lawyers got some exercise going up. But it's because the state just doesn't like the rules of how they have to present their case. It's so frustrating, like having to do this the hard way.
You guys were intimating this. I'm not sure if you actually were saying it outright when I was sniping you the other day for a few minutes. That it sort of made me realize there would be no case here at all if she had kept her mouth closed. If she had stayed in bed that night, there's no case at all. I mean, there's really nothing. If she had, maybe, I guess there's some sort of forensic evidence as far as her car going fast in reverse, but everything here is really hinging. If she looks so much guiltier, she would be so much more difficult to convict, certainly, if she just kept her mouth closed and didn't go out there and just stayed home.
Well, yeah, but okay, so the hard part about that is if he's genuinely missing and she's concerned, then she's going to go out and look for him.
No, I understand.
Right?
I understand. My point is, if she actually murdered him, right? So in that case, her smartest move is just wake up at 9 o'clock in the morning the next day, be completely sober, and then be like, oh my God, where the hell is Jean? As opposed to if she knew that she hit him, and she was trying to kill him, certainly. In that case, the smartest move for her to do is basically sleep it off. The fact that she's going out there in the middle of the night is, to me, indicative of the fact that she certainly wasn't trying to kill the guy. I think that in fact, I haven't heard any evidence to support the mens rea of an intent to kill. But it's really just a hard lesson as far as keeping mouth shut, because everything here looks so much worse because she says things like the last thing we had was a fight, right?
Right. But I mean, the last bit, that whole day was a fight, right? And that sucks.
I hit him. Yeah.
That sucks if you. The problem is you have to assume for people to be perfect in their behavior that they plan to kill someone. Right. Otherwise, their rather normal behavior looks really bad. But like their entire last day was a text fight that we saw that probably had some words exchanged, maybe a little sharp remarks there at the end. And now your boyfriend or whatever, for how long, is dead in the snow. And the last thing you said to him was like, fuck you, I'm going home. Right. That sucks. There's no way around how much that sucks. And if they're doing a mental health evaluation, that's a traumatic thing that she's in, right? Like that's where she is right now. The person who I was in love with is dead. And the last thing I said to him was, fuck you. Yeah. Like that is the worst thing that the person could be thinking about at that time for their mental health. And that doesn't mean that she killed him or that there's even evidence of it. That's just, holy fuck, now he's gone. And this was the condition. The fight seemed completely normal to me in the text message thing, like normal as in between two people. And there's nothing that indicates to me that fight leads to a murder in any logical progression. Something else would have had to happen for the murder to come out of those text messages. And it seems to me that it's just I don't know. I think the guy died from activity that happened inside the house after she left. But that's my theory.
And you're certainly not alone in that. The injuries are difficult to match up as far as how she has an injury and how he has an injury in the inside part of his arm and on the front of his head. Like it's hard for me to understand how this is consistent with one pass by of a car. It's just very difficult for me to wrap my head around. I also wanted to ask you guys a couple of things about today's testimony that I think are interesting to note. Number one is the blood alcohol level is being taken of her 6 hours later. She obviously the body has time to sober up, and that's why they're going to try. The state will likely try to speculate that whatever level of alcohol they're able to measure of her at 6, 7 a.m. is, let's relate that back to her finishing drinking at 1 o'clock. But that only calls to mind, we don't know that she didn't drink for hours on end. When she got home, she had 5 hours to go out and get drunk with no reason, that's prohibited for her to go out and get drunk. So there's all these assumptions, which I think to some degree create a reasonable doubt as to that she was this level of drunk at that time, assuming she even was above, the legal limit.
If she went home, especially if she went home angry or after having, they have this fight all day, they're finally going out, things are going well, and then the night ends with a little tussle between them. She doesn't go home with them, obviously, which kind of so she's going home alone. Yeah, she gets home, she cracks open a bottle of gin and starts drinking it. And
she certainly, even her text messages implies that when she's feeling frustrated, she drinks. So, there's a lot of reason there. There's a lot of reason there to assume that it's very possible that she did, to at least create reasonable doubt, that as far as her level of drunkenness, if her level of drunkenness is being held against her, to create a notion of there being some sort of intent that it changes the barometer for when you conform mens rea by drinking and driving and then hitting someone, that if that were to raise that up to.
But then we have all her interview videos, which don't look great.
No, that's another part about keeping her mouth shut. That was terrible.
In fact, I have them spooled up. You want to run through them real quick?
Yeah, sure.
Run through them.
Yes. Before I forget, I'm gonna forget. The reason I think they were asking him about the did you see any other women there? And he said he only saw Kerry Roberts and Karen Reed. Jen McCabe obviously was driving around with them also. She's the sister of Brian Albert. So as far as I understand, her sister-in-law, she's definitely related to him. She's been to that house many times. And some people in my chat had been saying that in the first trial it came out that she slipped into the house in the middle of the night, which only raises more of a question. If she was in that house, why the hell Brian Albert didn't come outside? Right? I mean, you can understand that if someone dies on your brother's lawn, you're going to go into your brother's house and be like, what the hell happened, even if you're innocent. The defense wants us to think that Jen McCabe, because of her Google search and everything, was in some sort of cahoots there with Brian Albert. And that's why maybe she's sneaking in there and having some sort of further conversation to help further along their conspiracy. But let's assume that there was no conspiracy at all. You can understand her going in there and saying, hey, oh my God, John O'Keefe is dead on your front lawn, in which case they would definitely wake Brian Albert up. You can't tell me he's asleep and that's why he doesn't notice everything happening here with him if his sister came into the house. So I think that's why the defense wanted to make a big deal about the fact that Jason Becker didn't see Jen McCabe, because I think they suspect that that's the time during which she was sneaking into the house, and that only raises further questions on this whole thing, right? I mean, that's all my speculation, but I'm wondering what you guys think about.
Well, you said you can't wake him up. I mean, it depends, right? Because if they did all just have a long night of hard drinking, and it might be really hard to wake him up. I mean,
yeah. All right.
If the guy finally there's a difference between people who go to sleep and people who black out drunk and pass out. And if that's the case, for whatever reason, this guy, even if it's all in good natured fun, he gets hammered out. He plops down. Your friend
is dead on the lawn.
But it's not that they're not getting up. Like you could shake them, you can yell at them. I mean, when people are blackout drunk, you cannot get them to wake up. They're just not gonna.
They're not asleep. They're like under anesthesia. It's not the same thing.
And it's like they can't comprehend that their friend is dead on the lawn. Like that wouldn't make sense to them at all in that state. I don't think. I didn't usually get that drunk. So, but I'm talking about people I've tried to wake up who have been that drunk. And it's like, brother, you need to get up. You need to get out of my house or whatever. But you need.
What do you guys think about this question from my community? What did jurors really think of constant sidebars? I've never been on a jury, but I would imagine they're thinking, "Oh my God, they're wasting even more of my time."
Yeah.
Look, jurors are there to determine whether someone is guilty of a crime, and in a murder case, they know that they may be taking someone's life away effectively, not with the death penalty, but with incarceration for a life sentence or effectively a life sentence. And so they want to know as much as they can stomach going on. And so anything that happens where they have to watch other people engage in a conversation that they're not privy to while they're supposed to make this really, really important decision that's going to take 6 weeks of their lives to make, that pisses them off, of course. But what are you going to do about it? I mean, the other thing is to, you can have open argument on objections instead of going to sidebar at everything. This judge is really lax on how objections are presented. It's just objection, doesn't seem to want you to call for a rule or make any argument on it.
Someone on my feed said she ordered pre-trial that there would be no speaking objections. So,
yeah, I mean, I know you don't want to have the person get up and make this long exposition about every objection, but it is nice to just say hearsay, foundation, relevance. One word objections to the rule would be nice. Indications to the rule would be great. What is the grounds for the objection? But we don't need giant arguments on everything unless the judge wants it. What's up, Joe?
No, and in answer to that question, I don't think anyone on this panel would have greater insight about what the jurors think. It's probably the same way any of you would think when you're sitting here watching and they're going off the sidebar. It's the exact same thought you're having when they're doing it is likely what the jury would have it. We're kind of sitting in the shoes of the jury here. The advantage to watching with a panel like this, with attorneys, is you're able to better understand the legal mechanics and things of that and legal strategy. So you have a better feel for what each side is trying to do and the effectiveness, fairness, or questionable partiality of a judge. So these are all that's what that's what we give you. But as far as what the juror is thinking, the three of us and every person watching this stream anywhere in the world are no different from how we feel about it than a typical juror, likely.
And that's the point of juries, is to find, someone from the everyman is the juror. It could be anyone from any walk of life. This is why I think it's funny when the lab tech is up there talking about, light spectrometry at the 340 nanometers of light, is that you could hear him pounding on the machine. He's like, this baby's got 340 nanometers. It's like, come on. But the
free financing.
You could throw a handful of darts at a Kanye concert and not hit a single person who understands mass spectrometry. Like he does. And so he just says it. And he goes into all these deeply detailed technical explanations. And that's why I was frustrated. Sorry about the mic feedback earlier, but I was frustrated during his testimony because the judge is allowing him to do these long expositionary explanations of the highly technical processes. And it's like, no, let Miss Little ask him the questions, because she was clearly asking him questions about this process and how it works one step at a time.
Yeah.
And if she had asked him to explain the whole process or whatever, the judge would have said, come on now, like that's too much. But instead, the judge just did that because he wanted to explain why his process is acceptable. No, it's just as good. It's just as good. But it's not just as good, which is why you're not forensically certified and why they would not forensically certify your lab under any circumstances. You cannot use that method of blood alcohol testing in a forensic capacity. And he explained why. Produces results that are 18% higher. And if you're going beyond a reasonable doubt on whether or not someone's drunk driving, in this case, take everything out. If they BAC'd her at a 0.093 and charged her, and she says this test can produce results 18% higher than the real test, 18%, you take that 18% away and it's a 0.078, and she's no longer over the statutory limit. That's a huge problem. And that's why his lab's testing results should have high amounts of discredit to them.
And theoretically, could be like deemed a type of junk science because you're not more informed. If anything, you're more likely to be confused, right? I mean, it's a downward
junk science for a criminal case.
Yeah, and
great.
Yeah,
great for treating people in a hospital setting, which is exactly what they said.
Precisely.
This is about care, not testing.
Great point. Yeah, great point. Yeah, that's not that junk science is too strong a word, but it's junk in the context of what we needed here. And it's perfect for treatment. It's a great point there.
And people do believe, lots of people believe that there's just you just do a drug test, or, oh, you just do an alcohol test and then it just spits out a result and that's accurate. No, they're like deeply detailed processes that are highly precise, and they're targeted. One of the problems with testing for drugs, for example, is you have a specific test for each drug. And so it gets really expensive when you want to just, well, see if there's drugs in the system. It's like, well, which ones? Right? Like because they have tests that test for 5 substances up to 15 substances. If you want to just see if someone has fentanyl in their system, you can't just say take a drug test. You have to take a drug test with one of the panels plus a fentanyl addition, because it uses specific reagents to find these things. These are not precise sciences in the way people think they are. You don't just go and like, oh, they just pour pee into a beaker and suddenly they know all of the drugs that are in there. Doesn't work that way.
Mm-hmm.
And the numbers don't work that way either. But again, everybody, it's like the assumption that law enforcement does this, so it must work right. Like, this is how we rely on putting people in jail, so it must work. And it often doesn't.
We're 1 week now. We're a week into the trial essentially, and I was wondering, like, if you like initial assessments about the effectiveness of various attorneys and judges after the first week of this retrial. So as far as like who, to me, Jackson is the strongest force in the room. I think
Jackson's great. I won't reiterate right now. I'll wait till the end of the discussion about, I think Jackson had a huge miss on that objection to the 2 video clips on day 2. But other than that, everything I've seen and heard from Jackson is fantastic. And I think he's a great attorney. He's very clear. He has great presence in the courtroom. I don't think the jury would find him unlikable in any way, but he doesn't come across as like soft either. I mean, he's clearly there to do business.
He's an advocate. Yeah. Is an effective advocate. I know what you're talking about with respect to that video, especially the one, he had a partial win. After John O'Keefe's mother testified, everyone in the room, anyone watching that, you have to be a soulless, heartless demon to not have been moved by the tragedy that this woman has suffered, first with losing her daughter and son-in-law, and then the kids going over to John, and then John's death, and the way she was broken up on the stand, which anyone would be. I mean, it was very heartbreaking. And what the prosecution wanted to do, in case you weren't here on day 2, was they wanted to make Karen look like an utter biatch. And the way they wanted to do that is they wanted to play a clip of Karen refuting something that the mother testified about. The mother was asked if at any point she leaned over the counter and said to Karen, he looked like he'd been hit by a car.
The island, Joe. The kitchen island.
He leaned over the kitchen island and said he looked like he'd been hit by a car. She said she never said that to her. Nothing of the kind. Then there's a clip from an interview where Karen Reed snarkily says in a mimicking voice of the mother, he looks like she leaned over the island and she said to me, he looked like he'd been hit by a car. And it looked like she was mocking the mother. Now, the state loves the idea of this because you have Karen Reed implying that he actually was hit by a car and not beaten to death by his friends or had some other type of tragic accident. B, she looks cold and evil, especially when you play that clip right after seeing the mother crying on the stand about her genuine, awful, terrible tragedies. And so the state wants basically the jury to despise her as like, how heartless and cold are you that you're making fun of this mother who suffered through all this tragedy? So there's no reason to play that clip. There's no probative value to it. And they had this whole argument because the state wanted it in. And Alan Jackson was arguing, no, it shouldn't be there. And if anything, you could have it as a written statement, but to have her up there on a video looking callous in that way it's highly prejudicial. I mean, that was highly prejudicial. He got a partial win in that it didn't get played that day. It was held off to the next day. So it's not, you don't have the raw emotion of seeing the mother crying and having your heart break for her, and then 2 seconds later seeing Karen Reed. When there's a full day and you sort of don't have as fresh in your mind the mother crying there, I don't think it's as terrible, but it's still that was bad that Judge Cannoni let that in my opinion. I was like, I don't know why we're watching this now.
Well, and I think Nick will address this, but there a particularly bad reason why she let it in.
Yes, and that was everything you said, I agree with. But I think the purpose of the prosecution is exactly what the prosecution said at their argument as to why they should be let in. I think they were very candid with the court and very candid with the defense. They introduced it as consciousness of guilt evidence. And then they laid out before the court and before the defense exactly what that argument was. And none of it relates to what's in the attachment to the clip versus his argument is so tenuous and embarrassing that it shouldn't have stayed. They didn't object to the first clip coming in, and that's where most of the argument took place. But now the prosecution on close gets to make a consciousness of guilt argument. They can call back to those clips, but the jury doesn't care what's in the clips. The jury cares that the prosecution gets to tell them, and she was saying these things because she was conscious of because of her guilty conscience about what she did. She took the murder weapon away from the scene. She was talking about what his mother said because of her guilty conscience. That's what the jury will hear on close 6 weeks from now. And the attachment to those clips doesn't matter, but that argument will matter a lot. And he laid it out right to the court. So they can't say they're taken by surprise. They can't object to it later. Like that doesn't have any connection to the evidence because they said, okay. And they lost the objection. To me, that's the most impactful lawyering the prosecution has done and the defense has failed so far in this trial. And I think it's very critical, honestly.
Yeah, and I heard you were bashing Brennan's opening on Viva Fry when I saw you on there, and I personally
The
didn't,
state's opening.
the state.
Yeah, I hated it.
I didn't think it was that terrible. I when he was done talking, I was like, wow, she looks really. I came into this fresh. I'd never seen this. I was like, yeah, there's a lot here. She's saying she hit him. She hit him. There's all this fragmentation, and I thought he did a sufficient job. I was like, this is a pretty decent job. By the time Alan Jackson was done with his opening, I was like, whoa, okay, we got like a real murder mystery here. And I liked his opening a little bit better. But I think that
Give me the three best points of Brennan's opening argument for you.
The three best. Well, I'm trying to remember now. We're going back to Tuesday.
Just in broad terms.
Well, he's got to be able to back it up, but it was the science, the math, the physics will show you.
I want from Joe's impression of Brennan. I want his three best things. This is not like a trick question. I just genuinely want like the three things where you go, okay, these are the three things from the state that stick out to me.
So one of them definitely is that he was hitting on how we have forensic evidence in the form of ways and alcohol testing and the Fitbit and the whatchamacallit. We have her own admissions, whether it's testimonies or things that she said at the scene. I thought that he laid out fairly well as far as nothing. And what I felt he missed on was intentional murder. But I felt that when he's hitting on
killing me.
What?
No, keep going. Sorry.
I'll tell you this much. When he's talking, I like the way he even laid out. He's like and then she goes in reverse, not rolling backwards, not a quarter speed, not half speed. Hits the gas at 3/4 as hard as that pedal can go down when she's going out in reverse there, and hit him with a car. And it's these are the injuries he sustained, and then she just left him there. And I felt as if overall the overarching theme I got was like, yeah, she probably accidentally ran him over there. And
what did your wife think about the gas pedal testimony, Joe?
Oh, shut up.
I mean, you don't.
I actually said after I heard his. I wish that were true. I actually spent like 9 hours driving on Monday. I so wish that were true. Yeah, I
like to kick up my feet, so I drive from the passenger seat.
The one problem I had with his opening, and this is I felt more of a fact problem than his issue, is you're telling me she's drunk. I don't know if she can form an intent to kill a guy in that sense. And then you want to tell me she's furious at him, so she hits the gas really hard, and that's her effort in hitting the gas really hard is to try killing him. If that's what you're trying to sell me, I'll tell you this: a woman is behind the wheel of a car, and you're telling me that she's furious. She is going to slam on that gas pedal, and she ain't trying to kill nobody. She wants her man to know she's mad, and the same way they'll slam a door or whatever. And a lot of guys will do this also. So you can't tell me that she's mad. And the reason we know she's trying to kill him is because she hits the gas that hard. I'll tell you right now that's not even, forget about guilt beyond a reasonable doubt. I think the prominence of evidence is kind of thin there to establish that her objective was to try and kill him rather than to make a statement to him of I'm mad and I'm steamrolling out of here. But
okay, so that
go ahead and dissect it why you thought it was so terrible.
No. What I found most interesting, this is again, I wasn't going against you here. All of what you said was great. But when you first described his opening statement, you said two things. You didn't say them when I asked you what the three most important things were, but those were the two things that came to your mind when you weren't thinking about it at all. And it was I hit him was the first part.
Mm-hmm.
Right? And I just find like that is the most devastating part of her case, or their case, are these admissions that she has over and over and over, alleged admissions.
Mm-hmm.
And that's where I thought Brennan's argument or opening argument was the best, is focusing on that. I hit him. And now they've got that established in the first couple witnesses. I think that's really bad for her. And I think that's going to stick with the jury when they think about what's been going on here. The first thing they're going to think about when they think about the prosecution's case is I hit him. And that's what, in your natural flow of conversation, that's what you hinted at. And I love that. I was so annoyed though, that you didn't get back there when I asked you the three most important things.
Right.
But my main problem with his opening argument is that, okay, he establishes that that's a big part of it. He establishes the forensics. I do agree with you that that's really, really critical, but I don't get the story out of him at all. It felt like it was, I have this piece and this piece and this piece and this piece, but I'm not seeing the picture when the puzzle's put together. And that was my main problem. Like, you're losing me. I don't know why any of this is going to matter. And you haven't built an arc that tells me why it's going to matter.
Okay.
Going through it. And Jackson's opening statement, it starts off strong. Like, he flat out, he's just like, this didn't happen. And then he goes through why you're going to hear that this didn't happen, and all the problems with it. And I thought that his narrative was better. Like you said, by the time Jackson's done, you're like, no, this beyond a reasonable doubt. No way did they get there at this point.
Yeah, I mean, the other, it was so effective that when I was trying to explain to Lady Lawgic why on day one, I started really enjoying this case, is I went over to her and I said, this is the opening. And I went through the opening far more thoroughly than I just did now. And I'm like, they're talking about, they got his DNA on the back of the car. They've got her broken tail light all around his body there. When you first hear him explain that, you're like, all right, her broken tail light is all around his body. How the hell could that not be that he hit her? And then you find Alan Jackson coming up there saying this never happened. Oh, you're going to remember the name Michael Proctor because he did such a bad job in this investigation that they had to fire him for his work on this case. That's how bad it was. And then he took possession of that car a couple hours before telling anyone he had possession of it. And then after they'd done a search once, twice, and on the third time, all of a sudden, after he gets the car, boom, now we have fragments from her tail light all around his body. I'm like, oh my God, this is crazy. That's when I fell in love with this case. It was during Alan Jackson's opening. And then we had that first witness that came out there. And when he was being impeached, I was like, this case is going to be crazy. And I do think that this is a really fun case. I'm looking forward to the next 6 weeks rather than dreading day by day, which is awesome. But the point I'm getting at, yeah. I'm not saying that she's guilty. And I'll tell you, I don't understand how his DNA would get on there. I mean, if he's wearing clothing, I don't understand what the hell is happening here.
Look, wait, so this is girlfriend's car?
Yeah.
if you want to understand how his DNA, like
Oh yeah, he could have
DNA
opened the trunk. Yeah, he could have
gets
touched it.
everywhere.
Yeah.
If you own something or are interacting with it relatively frequently, DNA is going to get everywhere. The trick with DNA is always, are they swabbing the right place? Did they happen to find a spot where DNA has made it and been preserved at that?
I don't even understand how his DNA would get in the car in the cold winter if it's that from a
I mean,
swipe
DNA
by.
doesn't like bundle up and stay in for the winter. Like it still gets on stuff.
You asked a great question. This is something else that when I was snapping you, I caught like I think the best of your coverage perhaps. So if not, you guys have been killing it. When you made the point as far as the tail light smashing outwards rather than inwards, which is something I hadn't personally thought of, but that the idea that it would smash outwards into him rather than his head pushing it inward and then it would just sort of like stay there, you know, it wouldn't all come shattering out right then and there. It doesn't, that's hard to understand how that would happen, and does make it seem more like someone sprinkled those pieces around his body.
It's like a bomb, like an IED tail light.
Yeah. I thought that was a great I thought that was a great point that I myself had not come up with. Yeah.
Yeah, and I want to see how the state tries to get the forensic recreation to show me all these lacerations. The only thing I can think is that on his up near his deltoid, the upper arm, you have these big horizontal gouges. And to me, that's the closest I can get to saying, all right, if I see a jagged edge of a taillight, and if it happens to catch the arm just right, and it can gouge across horizontally, that makes sense. Like cut a couple
one
furrows.
laceration.
Right. But that's that's a laceration. That is not shards like
everywhere.
Right. This peppering of the arm. It looks like he tried to kidnap Rambo's daughter or something.
And as Andrew had pointed out, far broader range than the size of the tail light. I mean, it's 18 inches across. There are lacerations across like 18 inches, and that tail light looks far smaller than that. I don't know, but that it's spreading out throughout his arm. I agree that, and also, really, let's face it, there's no bruise other than the only bruising he got from getting hit by a car. Not on his leg, not on his hip, not on his chest. The only bruise is like what he's leaning head first and arm first into like this into the driveway where what is happening there? What bodily position could he be in that he gets no injury, no bruising at all? Anywhere from toe all the way up to armpit on his torso, and only on his arm and his head. I don't understand how any person has ever been hit by a car that way, unless they were laying across a train track or something like that, and laying across a road like that. That's the only way that would happen. So
okay, you say that, and I 100% agree. But I've also watched dash cam videos from India, and I know that no matter what you think can't happen, it has happened in India. It has been caught on camera several times. So I'm willing to entertain the theory. I don't see it, but I can be shown, but I'm gonna need it to be done with some guy on a bicycle in the background. Gonna need a train going by with too many people on it.
Right.
And
in the street this wide.
Exactly. But that's like, my point is, I know that I can't see it. I can't see it at all. That doesn't mean it didn't happen, though. The unlikely happens all the time. The unlikely happens in catastrophic ways, with more frequency than we want to admit. It's just unlikely for that situation. But a whole lot of shit's going on in the world all the time. So there's always opportunities. But yeah,
the other thing that killed it, that Alan Jackson like blew my mind with, is that snowplow guy saying that he went by there at 3:00 in the morning. There's no body there. It's like, wait, what the hell? It's like the vanishing body between that wasn't there at 3 o'clock in the morning, and that was there when she leaves it, and is back there again at 6:00 in the morning. To me, I'm just like, we got like, this is a real mystery. This is like a whodunit. And you got to get proof beyond a reasonable doubt. They're gonna have a hard time. It's a hard one. If not for the fact that she opened her mouth,
So what do you guys think? Now, I think the popular opinion, or a popular opinion out there, is the at least some level of conspiracy and cover up of this. Not necessarily an intentional murder, but cover up of the death, however it was caused, by the people at the party. And then, of course, pinning it on Karen Reed. They're all cops. There's problems with the investigation. So the rumors of conspiracy obviously are there, right? Do you think it's wise for the defense to try to build a conspiracy argument, or is it like more directly, or should they just aim for reasonable doubt and not go for the conspiracy? Because you don't have to present the thing that may have happened, and that can cause a lot of trouble for you if you try and can't really sell it. So what do you do in this case? Do you go for the conspiracy?
Well, I think a lot of this, conspiracy is a strong word, right? Did all these people sit around the table and orchestrate all this? I mean, that's probably not what happened for all these people. But are all these people friends with each other? Do they socialize? Did they go to the high school junior prom together? I mean, and once they do that, do we have this contamination of memories? And people want to reinforce their friends' perceptions of what happened. And so you end up with it's almost like a subplot conspiracy as opposed to an active conspiracy. It's an incidental conspiracy. I mean, Karen Reed could be completely guilty, right? She hit this guy with her car, drove home. These people don't know anything more than they know now about it, but they would still be contaminating each other's memories, right? And if a lot of the most damaging testimony is they're recounting things that are not their personal memories, but things that were kind of inserted into their minds because of recollections that other people said they had, and those things are damaging, the defense still has to address the damaging testimony. Is it credible? Is it contamination? Is this real? Did you actually hear this? And then people have to say, well, no, I didn't actually hear it.
Right, like Carrie Roberts when she recreated everything with Jen McCabe and wrote it down. Like
you can't let that stuff stay in front of the jury as if it's unimpeached.
Yeah.
So I tried to talk about this in my own case, because the word conspiracy just means people acting in concert towards a particular end. It doesn't mean that they set out to do it necessarily. The conspiracies manifest at different times. My case was not a conspiracy against me, but there are certain things that happen that can where people do act in concert for a purpose, and they have a conspiratorial purpose. Even it doesn't mean that they are framing someone or whatever, but how something can be handled can be. This is not from the government. I'm not talking about government in my case, people. I'm just referring back to a prior conversation that I had. But the other thing you have, and this is where I think people, this applies in all contexts, and people undervalue how little needs to be done to fuck someone over completely, intentionally or unintentionally. A government worker missing something by accident can be the difference between someone going to prison forever and not going to prison at all. And in the same way, like Andrew's talking about, these incidental conversations that you have with your high school classmates, your coworkers, in some cases, your coworkers' wives are getting together, that those types of conversations create this. And it doesn't take much to really hose someone over, even when everything's legitimate. Or sorry, where Karen Reed is completely innocent and no one interfered with John O'Keefe on his own. Like maybe he just died outside. Who knows? Meteor hits him, for example. And there could be no.
I would explain the lacerations better than the car.
Exactly. But it really doesn't take much. I don't know. That's why I'm curious on if they should go for try to convince the jury that there's a conspiracy of information. Maybe that's a better way to say it. A conspiracy of information.
So, for example, when you were saying that just now, and what Branka was saying, imagine there is a cop who screws something up, and another cop sees that he screwed it up, but you really can't unspill that milk. So you would basically be like, all right, I don't want Jason to get in trouble here. So, we're friends for the last 30 years. I'm just going to help cover that up, that he screwed that part of it up. Not that I want to see Karen Reed go to prison. I don't care about that. I'm not looking to get her. I don't have an anti-Karen Reed bias. I'm just trying to protect my friend here who from the embarrassment of having this screw up being called to light. So they'll start to cover up for each other in that sort of way. And it ends up that if you're cynical, you can look at it and say, like, they all want to see Karen Fry, you know, but that's not the motivation. The motivation is there's a screw up, which is followed up by people being like, oh, I want to protect this person from facing repercussion for that screw up, not I want to punish Karen Reed for some reason.
Especially if they genuinely believe she's guilty, right?
Right.
They don't have to have the evidence. They don't need proof beyond a reasonable doubt. They just conclude she killed John. Well, then it doesn't matter what they make up about her or
Right.
what they pretend they knew, because it's all in a good cause.
We're getting justice done by lying. We're lying to get justice done, or we're putting this together to make sure that she actually, you know, that our friend see and his family see justice get done for them.
There's a plot summary of every detective show on the planet. It's like, yeah, we have to look over the procedures and protocols that are there to protect rights, because we know the guy's guilty. We just got to find the way to get there so we can arrest the guy and prove it.
Right. Everybody knows she's guilty. Well, if that's what they believe, then everything's fair game.
Right. And then you feel like you're not being bad. You feel like you're acting on behalf of morality, right? I mean, you feel as if you're helping make the world a better place by telling this lie, because you're ultimately seeing justice get done once you reach that conclusion.
And we've just summarized The Wire. All of it. Thanks, Joe, for explaining McNulty to us.
I never saw The Wire, actually.
It's really good. It's really good.
I got a half hour into the first episode, and I was just like, this is so slow. I was like, it was the first half hour was just like, and I don't remember what happened, but yeah.
I love the first scene though. The first like 5 minutes is just it's the funniest conversation.
I don't remember it. I just remember like I was like a half hour in, and I was just like,
1 second, be right back.
Yeah. Anyway, so yeah, so we were talking about the effectiveness of counsel and things of that nature. What do you think of the state prosecutors so far?
I mean, they're methodical. They're stepping through what their argument is. I don't see them making big mistakes. They tend to overreach like prosecutors tend to do. Make more out of their evidence than it actually is, but that's to be expected. They believe she's guilty. They're trying to prove a narrative of guilt beyond a reasonable doubt. They're always kind of scuzzy. So, I mean, when people say, "Oh, these prosecutors did horrible things," sometimes that's true. Sometimes they're really bad. Sometimes they're, Binger bad.
Right.
I'm not seeing that level here. I'm seeing a pretty typical prosecutors taking what they can get. It is an adversarial process. The defense is supposed to check these guys when they're overreaching too much, and of course, the judge is supposed to be there to enforce all that. I don't have a problem. I think they're very low. They're low energy. They're no Alan Jackson.
Right.
Which is why they're public prosecutors, and Alan Jackson's, makes a lot of money doing what he does.
Right.
Ionetti, is that the other guy, the local guy in Counsel? He's good too. I like him.
Yeah, I'm not sure it's Ionetti or Ionetti, but yeah. He pronounces it Ionetti. He pronounced it Ionetti when he addressed the jury today. So, but whatever.
Okay.
Yeah.
Yeah. Ionetti. That's what it is. David Ionetti.
Yeah.
He's good. Elizabeth Little, we heard for the first time today. I mean, I didn't hear much from her. She sounds like she's asking questions off a piece of paper that someone gave to her.
Yeah.
She comes
She's
across to
relatively
me.
new. She's new. Like
Someone said 8 years.
8 years. 8 years can be kind of new. I mean,
I guess it depends on what she's been doing, right? A lot of lawyers, or 20 years, are never in a courtroom. So,
true.
But anyway, so I wasn't super impressed by her, but maybe that's appropriate for where she's at. I don't know. Then there's that guy, Robert Alessi, who strikes me like if Elon Musk became a criminal defense attorney, kind of on the spectrum, really, kind of bothersomely loud. Like, why is he so loud all the time? It's like he's always yelling at the judge all the time. I'm like, and he throws in words like forthwith and post haste in a way that, if I ever came across like a fake lawyer in a courtroom, I'd expect him to be behaving a lot like Robert Alessi. Not that I'm saying he's a fake lawyer, but it's just kind of an odd way of presenting himself in a courtroom. And I don't know. I don't know what to say about them. And then, of course, there's the last lawyer who's not really a lawyer here, but I guess she's kind of advising the team, Victoria Brophy. She's the one who was the juror in the last trial.
Right.
Georgia. But I don't
know. I thought it was Victoria Georgia. Was I wrong on that?
Oh, maybe it's 3 names and I missed one. I don't know.
Okay.
But I don't expect she'll play any kind of a substantive role that we'll see in the courtroom. Every time Jackson gets up, I'm excited. I just want to see that guy perform.
Yeah, he's great on cross. How many people has he impeached in his first week? I mean, he's really, really good at that. And even just presenting the tone that he's winning, like when he's doing it.
And he does it in a polite way.
Yeah.
I can say it because he's a white guy, but he's well spoken. He speaks calmly, right? He speaks reasonably. He's not like yelling at people.
Yeah. All right. So the next question, I guess, is Judge Cannoni. What are your thoughts so far?
Oh God, she's terrible. Ugh.
Yeah, go on.
I was just gonna say I hate judges who appear like they appear laid back and passive, like, okay, we're gonna let this thing happen, and then you start looking at the rulings stack up, and it's like, oh yeah, I'll contemplate this or whatever, and it's just states for the state every single time, and you're like, okay, I know the score. I hate it.
I just don't understand a lot of her rulings. Like she'll object, sustained, object, sustained, object, sustained, object, I'll allow it. And I'm like, but this is the same thing. I don't understand what's changed because there's no speaking objection. So there's no rationale provided. So I don't understand why she's allowing some things and not others. I can imagine why, but it would be nice to know how she's making these decisions. Otherwise, it comes across as arbitrary.
Yeah,
and it's arbitrary, and the state knows it because the state got denied, or they object, or yes, the state made an objection to something that was the defense made an objection to a state question that was sustained. State asked a couple questions and went right back and asked the exact same question with the exact same wording, and I thought she was going to overrule it. The state knows if they just wait, they could possibly get a favorable ruling even on the exact same question with the exact same grounds, and they're going to just push for it. And,
right, if it's random, right? If the objection being sustained is random, well, you just keep taking shots until you get lucky.
Yeah, and I think they know that she will be deferential to their position enough that randomness will not. She won't go, did I rule on this 48 seconds ago? Who cares?
Yeah,
Not a big fan.
I mean, look, it's in vogue to bash on Judge Cannoni. I understand that, especially people who watch the first trial can't stand her, and I haven't been impressed. I certainly cannot say I've been impressed by her. She seems. I've seen a tilt toward the state. I haven't seen it yet be that bad.
I'm gonna.
Well, I will say
the ARCA issues.
Yeah, I was going to say that ARCA question. What's going to happen on Monday? Because the judge appeared heated towards the defense. Like, I believe you've deceived me on this discovery stuff. I need you in here. I need your witnesses in here. I want them under oath. Yeah, we're going to voir dire your experts. I want to know what the deal is with these 100 or 1,000 or whatever it is text messages, and why they're not in the record and why they weren't shared. And Robert Alessi standing up and screaming that, well, these things were deleted forthwith and post haste, Your Honor. And she's like, I have no idea what that means. And I don't blame her. I have no idea what that means either.
I said the same thing. I was like, I don't know what that means either.
But she looks like she's primed to really issue some kind of sanctions. I mean, not in the formal sense, but make evidence inadmissible, the defense experts inadmissible, if they don't have a damn good explanation for. And I'm not even clear on what the questions are, but she's clearly upset about something.
Yeah, well, on that though,
she believes there's text messages. I believe is what Alessi is referring to, that there are text messages from 2 years ago between counsel and someone else, maybe Miss Reed, maybe an expert, that she asserted that they had an affirmative duty to preserve. And she says that those text messages need to come in. Alessi saying those text messages don't exist anymore, Your Honor. Like, they're gone. We have a record that we affirmatively produced that text messages were sent between this number, but that's the best we can do. We cannot get you the text of those messages because no one has it. It's not around. It's not there. And she seems like she wants those text messages before she's willing to let the ARCA testimony come in, or the ARCA evidence come in. I think that could crush Karen Reed's case if she doesn't allow ARCA in.
Yeah,
That's my understanding.
What
though,
I
but
understand about ARCA, and those of you who are unfamiliar with ARCA is a recreation team, which I think is often hired by the state, and in this case was hired by the defense, where they based on all the evidence they see, they try to recreate exactly what happened here, and supposedly it does a lot to help exonerate Karen Reed from striking him with a vehicle, and I guess that is consistent with our questions about how he doesn't have bruises and the weird places that he has, the injuries that he sustained. With respect to Canoni, I'll tell you this: if she's angry that she feels like she was deceived, that is not an uncommon thing from judges. Judges, if they feel as if you're BSing them and that you're trying to hide your BS, a lot of judges will become animals about it. That to me is not indicative of her being uniquely anti-defense. Now, I don't know what her basis is for coming to that conclusion. I don't know enough about what happened within the history of ARCA, but if a judge feels like you're playing games with them and trying to deceive them, they likely will come down on you with whatever force of God they think they have. So that's not surprising to me on that end. But go ahead.
I was just going to say that my feel for it is, and I fully believe that the state did this. What happened was the defense wanted to introduce this ARCA testimony that to get permission, I guess, from the federal government to employ ARCA. I don't know the backstory. I'm not sure why, but some level of permission needed to occur. And then the defense asked for the prosecution's forensic data on the car, and the prosecution dragged their feet for 6 months before they even produced their first report. They get the report. They say it's inadequate. The judge says, look, y'all's expert testimony, we need to know what your experts are going to testify to. And the defense is sitting here going, we're still waiting on them to provide what they intend to introduce for our experts to counter. We have to respond to the data that they're going to bring in. And what Alessi laid out, he's like, they waited 6 months. They got this. We responded within 48 hours. Then they waited 2 months. We responded within 24 hours, Judge. We are not dragging our feet. We are trying to do this. You imposed an arbitrary date on us turning this in, especially in a 6-week trial. But you impose an arbitrary date, and the state is trying to play out the clock and leave us with no time for our people. And we're still getting it to you. Now the judge is making bones over text from 2 years ago. And it's like, well, what did text from 2 years ago have to do with reports that are generated in the last 7 months? Well, we can't know until we see the text, except that's circular reasoning. If the texts aren't available, they're not available. Is there something wrong with the reports now? Are they violating the discovery on the reports now? It seems like the defense has a good argument as to why their discovery is delayed, and it's entirely at the hands of the state dragging their feet. This murder trial was over a year ago. And what took them 6 more months to get this data and start to prepare this report? They should already have something to give to the defense at that point. So now, but the state does this all the time.
So you're making the point that her basis for being upset with the defense is wrong, and that
So I got lost in what I was saying. My initial point is that it's the subtle bias towards the state, and you can hear it coming out of the defense and their frustrations over this discovery issue. We are in compliance with discovery. The state is dragging its feet, and you see every nod just going in favor of the state. Discovery violations on the defense, in my opinion, should have to be so egregious as to be obvious manipulation of data for the purpose of defrauding the court. Because it's the defense, you should be afforded every single opportunity to defend yourself. But all of the discovery deference that tends to go towards the state in a criminal trial. And it's frustrating because that isn't a protection of right or a presumption of innocence. Those evidentiary issues matter. And when you see a judge consistently rule in favor of the state on every little issue, it starts to add up, and it looks like a subtle bias that becomes a snowball effect, becomes a big monster, an albatross at the end of the trial.
Well, I've seen her sustain a lot of objections that AJ has brought up, Alan Jackson. So I haven't seen quite the level of bias that everyone claims. I may see more. We may see more and more of it. For me, it's like you're saying, it's a cumulative thing. I don't feel it's nearly as cumulative for watching just this trial. And I'm sure that a lot of people watch the first trial also and have formed opinions about Judge Cannoni from that. And perhaps, from that it's well learned. I'm simply saying, from what I've seen, just seeing the first 4 days of the retrial, I feel like she's leaning toward the state, but I've seen other judges be far worse. That's my own personal take. So
yeah, of course, mostly she's not doing. Someone asked me on
it's
Twitter,
early, though. It's only. Wait, go ahead. Sorry.
Someone asked me on Twitter if you've seen anything appealable. It's like, well, not really. It's just annoying.
Right.
But is it appealable? I mean, maybe in the appellate work on this case so far is going to be in pretrial motions and evidentiary motions that are not the courtroom drama that we're watching.
Right.
And she may make decisions there. On her objections and her admissions of evidence so far, I don't see anything egregious. I think the defense should have argued against those clips for that purpose. Although I think if the state wasn't going to make the consciousness of guilt argument, I think those clips are fine.
Yeah, that was actually the one call she made that bothered me the most, allowing those clips in, because that snarky clip, he made the point, why not just give a transcript of her saying it? Because it's all her tone, which was so terrible. And, where she looks like she's mocking the mother who everyone saw grieving. That's so much more prejudicial than probative. So much more prejudicial that there's no benefit to having the video. There's no enhanced benefit, at least, to having the video. Perhaps if you can argue the whole consciousness of guilt claim sufficiently well and tie it into that clip there, I don't even really understand how it displayed consciousness of guilt. But if the judge thinks that a jury
doesn't,
if a judge thinks that a juror could interpret it that way, then put the text in there.
You mean leading the kitchen island?
The kitchen island thing. Yeah.
Yeah.
The kitchen island.
I mean, the state's argument is that basically it's a fabrication of evidence, tampering with evidence. She's she's fabricating a claim that the mother said something that the mother didn't say. That's the conscious. So any tampering with evidence would be, it doesn't sound like tampering with evidence to me, but that's the argument the state is making. But to your point, if the argument is consciousness of guilt, you can perfectly make that argument with a transcript.
Yes.
Because it's simply the claim, right? The claim itself is the problem.
Right.
You don't need the tone. You don't need the sarcasm. Right.
Wish she looks heartless. Someone here in my chat just sent a chat saying during the last trial, defense asked judge to recuse herself due to a social connection to the McCabe family that refers to her as Auntie Bev. Okay, that would bother me. That would bother me a lot.
Yeah, there's tons of those issues, and they presumably have been resolved in favor of this judge staying. I mean, that's still there. Now, incidentally, today is her appeal is being submitted to the United States Supreme Court.
I don't think she's going to win that appeal.
I don't think they're going to.
I don't think
they're going to accept it.
Yeah, they're not going to grant it. I don't think.
Whose appeal?
Karen Reed is appealing 2 of her 3 charges as double jeopardy.
Yeah, what she claims is this. I mean, I went through her appeal on one of my live streams. So she's appealing to the Supreme Court saying that at the end of the first trial, the judge never bothered asking them.
Oh, right.
She never.
Okay.
Well, I'm just explaining to the audience.
Sure.
So the judge never. They went back and forth asking questions, saying we're hung. We can't decide. Can't decide. And the judge basically said, okay, mistrial. We're gonna have to do this whole thing all over again. And she dismissed them without talking to the jurors any further. After that happened, the next day or 2 days later, over the next several weeks, several of the jurors reached out to the defense counsel and said, hey, we saw there's a mistrial on all 3 charges. The first thing we decided on day 1 of our deliberations was there's no way in hell she's guilty of intentional murder. That's definitely not something she can be found liable for. And then we were arguing, and also on the 3rd charge about leaving the scene of the crime. All that we had was hung up on was this issue as to whether she had accidentally hit him with her car and that caused his death. So, and that's where we couldn't come to agreement on. The entire time, that's all we were fighting about. But we all agreed to this. Now, the way the law operates on this is it's nice that they came to that agreement up front. but it has to be said in court. And if it's not, the workaround, if it's not said in court, is that at the end of your deliberations, you have this unanimity about there being not guilty on certain charges. And while it's likely the case that once they put those two charges aside and spent the rest of the time dealing on the second one, it's very likely the case they never bothered talking about that. And it's very likely the case that they all finish their deliberations in agreement that she's not guilty of charges 1 and 3, unless they have that official vote. For all anyone knows, they may have changed their minds during the course of their deliberations about count 2. And accordingly, you cannot rely on that, even though it feels like a real injustice. And it's really a screw up by the judge. She should have said, hey, you're hung up. Are you hung up on charge 1? Are you hung up on charge 2? Hung up on charge 3? She didn't do that. That was her failing. That was a terrible, terrible failing. The defense could have asked her to do that. That was a little bit of a failing on their part, that they didn't ask her, say, hey, they're hung. Obviously, they must be hung up on, maybe they're not hung up on all of these, but then you're sort of running the risk. Maybe they're hung up on the first charge and they think she's guilty on the second charge, right? I mean, if you're the defense counsel, perhaps it's not a screw up, because until you know what the jury has deliberated about, for all you know, they're all sitting there arguing about whether or not she intentionally killed him, but they all definitely agree that she at the very least accidentally killed him. And maybe you don't want to hear what they have to say, and you don't want her polling the jury. It's a bit of the roll of the dice, which could end up with your client now sitting in jail for 8 years rather than having a brand new retrial. So you can understand that maybe it wasn't completely a screw by the defense. It was a tactical call not to have them be polled. The judge should have polled them, didn't. Now she's saying to the Supreme Court, hey, because they found me not guilty in their private jury room on charges 1 and 3, I can't face charges against that again, because that's double jeopardy. But frankly, the law doesn't seem, even reading from the papers from their side, to me, I don't see how they're going to get past the Massachusetts Supreme Court finding that under the law, it's not considered double jeopardy unless there was a new vote by the jury at the very end of their deliberations rather than merely having it at the beginning. But if you guys have other thoughts you want to add in on that, I'll shut up now.
I don't know enough about the issue. I just saw that it was the Supreme Court was receiving it today. They could decide on when they'll hear it starting today.
Mm-hmm.
But they wouldn't be hearing it today, just so there's no confusion on that. I mean, I don't think they're going to take it. That seems like a long shot in general, and it doesn't get her out of the, she still has a murder charge like that she has to defend herself against. Like this is still happening. But hey, who knows? I've got some chats here. Otherwise, if there's
I've got to bust on out of here. I've got stuff I got to take care of today. So I appreciate you guys bringing me on here.
Yeah, man, always a pleasure.
Anytime, Joe.
Yeah, I kind of sort of feel, I know a lot of people have asked me about streaming with you in particular, like the two of you in particular. And I love hanging out with you guys. I'm sort of very, very torn about it. I'll probably end up polling my community as to like what they prefer. Because sometimes I like just having myself, like where I'm able to just sort of, I'll stop the video for like 10 seconds, 20 seconds,
sure,
and fall behind. And there's a lot more freedom and latitude where I feel like I can give coverage in the moment that I would never even think to do if I'm sitting as part of a panel. So, but on the other hand, there's a lot of slow time, as we all know, during the course of a trial or different comments that end up enhancing the overall production when you have other intelligent attorneys that you're able to bounce ideas off of. So I'm sort of very torn about this, but I'm sure I'll end up popping in on your. I don't know if I'll be doing this more and more on a regular basis, but I'm sure I'll be popping in on your stream over the course of this trial for the next like 6 weeks or so.
Yeah, just keep in touch. Well, we can always figure whatever out. No big deal. It's always great to have you on, man.
Either way is fine, Joe. Whatever you want.
Thank you, guys. Awesome seeing you as always, and I'll probably see you sometime next week.
All right, brother. Peace.
Hey, let me hit my. See you, Joe. Let me hit my.
Get out of here.
My class one more time before we wrap up the show. I know you have super chat.
All right, so that's my story there. I will put a poll up, but I'll put a poll up right now. We'll see what people think. Is it better? Do you like me better individually, or do you like me better when I'm able to sort of stop things and do things at my own pace? Tell me in Rumble, like panel or solo. Just put in, if you could throw in there, that's very helpful. And I'll put a poll up in the better coverage. I prefer jurors coverage of trial. Solo or Branca. And if you're watching afterwards, I would love your feedback and comments. Whether you prefer solo or with Nick and Branca. This way I get a better idea as to like what I should do. Because and I'm probably gonna mix it up. No matter how the poll comes out, unless it's really slanted one way or the other, I'm probably gonna mix it up where like some days I'll be solo and some days I'll be part of the panel. Today it really lent itself toward being part of a panel because the jury was going out on some sort of lengthy. They were going out on a viewing, and I was like, I don't know if we can be here for 4 hours. We have no idea how long I'm going to be here. And I was like, I'm not going to be able to sit here for 4 hours straight by myself. So like, it made sense to join them and help kill that time. And once I joined them, I wasn't going to leave them once the trial resumed. That would have been rude and stupid. So, no. Okay, let me see. Oh, I can't. Why? Oh, I popped out the chat. That's why I don't see that. So this is interesting. I'm just reading through now. In fact, I'm not going to read it through. I'll do it like this. I'll bring it up on screen so you can all see the general feeling. This is what I'm getting from Rumble. Solo, talking over each other. Good to join up at times. Solo better for active streaming. Solo, I honestly like both. And solo Wookiee. And I get panel, solo, panel. Duckfat said something. Solo bring someone in on at night to discuss. Shake it up. All right, that's what I'm getting over there. Let me see how my poll is going. Seems to be leaning towards solo. I'm also I can't ignore the impact it has on my subs. Like if I'm getting more subs because I'm getting more people like through the crossover. I mean, that is a massive. It's not like I make a lot of super chats when I trial stream. It's really 50-50. Wow, it's 52-48 favoring solo. So I'll probably try to get a feel for how this impacts my subs because, like, as Branca points out, the reason I'm doing trials, the reason he's doing trials, it's not for the super chats. I mean, I typically make a lot more in a 2 hour stream in super chats than I will, and I'll have a lot more views in a 2 hour nightly stream than I will in a trial. But trials afford me fresh eyes and help my channel grow in ways that my nightly streams don't. So the objective here is ultimately views and subs. So as far as I'm enjoying the trial, but from a work benefit perspective, that's the primary principal benefit is getting new people to find me. And I think it's possible that I'll have more new people finding me if I'm there. It's interesting that it really is 50-50 right now. Now it's 51-49 Nick and Branca. I'm calling this 50-50. I'm definitely willing to start 50. This is true, Teresa. This is true. All right. I probably am going to. A lot of people are saying I should split it up, and that's likely what I'm going to end up doing. Some days with them, some days solo. And yeah, I consider both of them friends. You know, we all consider each other friends. Like, you know, we would hang out. So, and there's a mutual respect that we all have for each other's abilities as both lawyers and streamers. So, anyhow, yeah, I'm gonna wrap up. I'm gonna wrap it up over here because I got stuff I gotta get ready for Shabbat. So yeah, I'm supposed to be someone. Cool Frog asked me to join him, and I told him I could do Saturday night. I don't know if I've heard from him yet on that. So I might be there Saturday night. I don't know if I'm going to be streaming Saturday night or not. You'll find out at goodlogic.locals.com. It really depends on how tired I am, and if anything crazy happens in the world, I'm more likely to stream. If nothing crazy happens, I'm less likely to stream. But yeah, that's the story. Anyway, I hope you all have a phenomenal weekend. I thank you so much for joining me over here. And if you can like, subscribe, drop a comment down below, that's really awesome of you. And have a phenomenal weekend. All right. Don't eat the bugs. Godspeed.